Good morning, colleagues, Senate and Central staff, testifiers, our listening and viewing audience. The 36th Legislature of the Virgin Islands Committee on Rules and Judiciary hearing for Monday, September 8th, 2025 is hereby called to order. Before we move on to the roll call, I want to take a moment to recognize something deeply important in the month of September. September is Suicide Prevention Awareness Month. This is a time to honor those we've lost, support those who are struggling, and remind one another that help, hope, and healing are always within our reach. As discussions about mental health have changed, so too has our understanding of suicide. The Virgin Islands Department of Health advises anyone who is concerned about a loved one who could require crisis support to contact 988, text or chat with 988lifeline.org. Last year, 3 young Virgin Islanders died by suicide, leaving their families and our community shaken and mourning. No matter where you live in the U.S. or its territories, 988 acts as a universal entry point that allows you to get in touch with a qualified, compassionate counselor who can help. Trained crisis counselors are available around the clock at 988 to assist anyone in mental health-related difficulties, such as suicidal thoughts, mental health or substance abuse problems, emotional pain, and other reasons to connect. You can also contact 911 locally if you think there may be an immediate risk of self-harm. Today is also World Literacy Day. Every year on September 8th, we celebrate World Literacy Day. According to the United Nations Educational, Scientific, and Cultural Organization, most of us know it by its abbreviation, UNESCO, this day is commemorated to remind the world community of the value of literacy for people, communities, and societies, as well as the need for greater efforts to create a more literate society. Since 1967, World Literacy Day has been celebrated annually to raise awareness of the importance of reading as a civil rights and pride issue, as well as to advance literacy agenda for a more literate and forward-thinking society. Lastly, on September 1st of this year, Guyana conducted general elections. That's our neighbors to the south of us. And on September 3rd, the incumbent president, Irfan Ali, I'm hoping I'm not mispronouncing his first name, won a second and final term. We congratulate Guyana's president, Ali, on his re-election to office, and also congratulations to the people of Guyana on a peaceful, democratic election. Madam Clerk, kindly proceed to roll call. Present.
Senator Kenneth L. Gittins. Absent. Senator Alma Francis Halligan. Absent. Senator Angel L. Boyce Jr. Absent. Okay. Senator Clifford A. Joseph. Senator Clifford A. Joseph present. Senator Avery L. Lewis. Senator Lewis present. Senator Milton E. Potter.
Here.
Senator Potter present. Madam Chair, we have 4 present and 3 absent.
Thank you so much, Madam Clerk. We do have a quorum. I thank you, colleagues, for being here, for us to have a really good start for the morning. Madam Clerk, do we have any correspondences?
Yes, Madam Chair.
Kindly proceed in reading the correspondence into the record.
September 8, 2025. Honorable Carla J. Joseph, 36th Legislature, Chairman on Rules and Judiciary. Greetings, Senator Joseph. Please note for the records, I will be tardy for the Committee on Rules and Judiciary scheduled for 10 a.m. on Monday, September the 8th, 2025, in the Frits E. Lawaetz Legislative Conference Room on St. Croix due to previously scheduled appointment. I will arrive as soon as possible. Thank you for your understanding. Regards, Alma Francis Halliger, Senator Alma Francis Halliger, 36th Legislature, Member, Committee on Rules and Judiciary.
Thank you, Madam Clerk. I
present?
believe I see Senator Francis Heiliger just joined us remotely. So,
Yes, ma'am.
Senator Francis Heiliger?
I'm present.
Senator Francis Heiliger is present. Madam Clerk, kindly give us a tally of the number of members present and those absent.
The total is 5 present and 2 absent.
Thank you. Thank you so much, Madam Clerk. And colleagues, once again, I really thank you for being here. We still are sustaining our quorum. Madam Clerk, kindly read into the record Block 1 of today's agenda.
The Committee on Rules and Judiciary meeting scheduled for Monday, September 8, 2025, in the Frits E. Lawaetz Legislative Conference Room on St. Croix reads as follows. Block 1, 10 a.m. to 11:30 a.m. Mr. Roy Morehead, Governor's Nominee, Board of Parole. Yes, okay. Mr. L. Damian M. Cartwright, Governor's Nominee, Virgin Islands Board of Land and Use Appeals. Block number 2, 11:30 a.m. to Madam Clerk, that ends the reading of block number 1.
Thank you so much. It's a Monday morning, and we're here early, so we're going to have a little bit of a slip up. But Madam Clerk, I thank you so much for being here and for doing this work. At this time, we do have 2 of the governor's nominees before us for consideration today. We have a full agenda, major agenda today. We're going to be working on behalf of our people. And so we have Mr. Roy Morehead, who is the governor's nominee for the Parole, the Board of Parole in the St. Thomas, St. John District. And also we have Mr. L. Damian M. Cartwright, the governor's nominee for the Virgin Islands Board of Land Use Appeals. And he's going to be for the St. Croix District. I want to, as mentioned, we're going to swear the both of you in. And so if you will be kind, gentlemen, to stand and raise your right hand and repeat after. You don't have to repeat after me. You just have to say, I do. Okay, raise your right hand. Do you solemnly affirm under penalty of perjury that the testimony you will give to this committee will be the truth, the whole truth, and nothing but the truth to the best of your knowledge and belief? I do. Thank you so much, and kindly be seated. We will now ask Mr. Roy Morehead to proceed with placing your written testimony on the record.
Good morning, Honorable Senator Carla J. Joseph, Chair of the Committee on Rules and Judiciary, Vice Chair Kenneth L. Gittins, Secretary Avery L. Lewis, Honorable Senators and esteemed committee members, Senate staff, my fellow testifiers, and the listening and viewing audience. Thank you for the opportunity to appear before you today. I am honored to be considered for appointment to the Virgin Islands Parole Board by Governor Albert A. Bryan, subject to your advice and consent. This is a civic responsibility that I am ready to fulfill. My commitment is to uphold a justice system that safeguards the public and within the bounds of law, supports earned second chances. I recognize the trust that this confirmation carries, and I approach it with humility. I want to recognize the current board members, Chairman Dennis Howell, Reverend Dr. Bentley Thomas, Pastor Chesley Roebuck, and Attorney General Gordon C. Ray for their steadfast service and leadership. They have kept the board's work moving with professionalism and grace, often with limited resources and little fanfare. I am grateful for their example, and if confirmed, I will work to support their efforts and help build a board that is strong, secure, and fully equipped to meet its responsibilities. My goal is to be a prepared colleague who adds value and continuity to their work. My first responsibility is to listen, understand current practices, and contribute where I can be useful. I hope to meet with current board members, the Bureau of Corrections, the Department of Justice, probation and parole officers, victim advocates, and community partners to learn what is working well and where I can support improvements. I will also seek to visit facilities and observe their workflow that precedes a hearing, so that my contributions are grounded in the realities faced by staff and the public. I am a proud Virgin Islander, a husband, father, veteran, and public safety professional. I was born on St. Thomas, graduated high school on St. Croix, and have spent my career serving the people who raised me. My experience gives me tools. It does not give me all the answers. I am prepared to learn and earn the confidence of the governor, this body, and the public. At Havenside Mall, where I serve as assistant property manager and chief security officer, my work is hands-on and community-focused, listening to concerns, coordinating with first responders, and helping our guests, tenants, and their employees feel safe and secure. In a high-visibility setting with diverse stakeholders, I have led incident responses, developed policies and procedures, and worked closely with law enforcement and medical partners to de-escalate difficult situations. This type of work mirrors the demands of the parole board, both requiring balancing safety with fairness, weighing risks with accountability, and making decisions that affect real people in our communities. The judgment, neutrality, and steady presence I bring to my current role are the same qualities I will bring to the board: respect for victims, adherence to the law, and focus on ensuring that any decision serves public safety and community trust. My approach is steadfast and plain-spoken. Prepare carefully, weigh the facts, document the reasonings, and decide without fear or favor. I believe people can change and take responsibility for their actions. My role, together with my colleagues, is to balance public safety with lawful opportunities for earned second chances. I will ask questions as openly as I share ideas. and I will accept correction when it is warranted. If a matter presents a conflict of interest or even the appearance of bias, I will step back in accordance with the law and ethical standards. I am further committed to continuous training in parole, decision-making, and evidence-based reentry. Parole is a public safety decision grounded in law, behavior, and demonstrated change. It is a determination based on the record that supervised reentry is consistent with community safety and with the individual's readiness to comply. When accountability and readiness are shown, supervised reentry can work. When they are not, parole should be denied. Sound decisions rely on thorough preparation. Case files must be complete and eligibility verified. Institutional behavior and program participation must be documented. Risk and protective factors assessed, victim input invited, and proposed supervision conditions made clear. I also recognize the safety risks and pressures that come with this role, especially in serious or high-profile cases. That reality calls for clear procedures, appropriate safety protocols, and close coordination with our public safety partners. Board members should have access to legal support and protections. The process must also be structured to protect the well-being of staff, respect the needs of victims, and provide clarity for families involved. If confirmed, my short-term goal, shaped by the board's guidance, would be to support clear, consistent processes. I commit that I will ensure a quorum and our legal posture is sound before hearings, verify due process steps, eligibility, notice, and file access with DOJ and BOC prior to scheduling hearings, use a standard pre-hearing checklist so decisions rest on a reliable record, strengthen public notice and victim participation, including remote options, improve scheduling and communication so participants know timelines and expectations, and document decisions clearly, stating the facts and factors relied upon. In the long term, I envision a dedicated parole authority, an independent, fully staffed entity with the resources and operational capacity to manage case preparation, victim notifications, record keeping, training, logistic, and statistical analysis. This parole authority, developed in partnership with this body and justice partners, will allow board members to focus exclusively on adjudication while professional staff handle support functions. I believe in integrating tools that enhance accountability, transparency, and trust. Restorative justice is one such approach. Used in other jurisdictions, it centers on the voices of victims, requires genuine accountability from offenders, and supports safer reintegration. Offenders must show that they understand the harm they cause, take steps to repair it, and demonstrate readiness for a responsible return. For victim engagement, I support adopting the Victim Information and Notification Everyday System, VINE. This tool, already used in over 45 states and US territories, would close communication gaps and give victims timely, reliable updates. Equally important, victims and families must have a genuine opportunity to be heard before any release. Offenders seeking parole must show that they understand the harm caused and have taken meaningful steps to address it. To strengthen victim engagement, I propose 3 priorities. Implement or partner with systems such as VINE to deliver timely alerts. Improve multiple avenues for victim input regardless of hearing location. Enforce clear, consistent public notice with sufficient advance time. Victim engagement must go hand in hand with reentry coordination. When parole is granted, the conditions should be clear, supervision expectations defined, and practical supports in place before release. Accountability and support are strongest when delivered together, never as afterthoughts. If confirmed, I will measure my service by how well I listen, prepare, and decide each case on its merits. This is serious work with real consequences. I will judge each case on its own merits, grounded in laws, facts, and public safety. Beyond the policy and procedure, I also believe the Parole Board plays a role in something deeper, offering a sense of hope, particularly for younger Virgin Islanders who may have made serious mistakes early in life. The parole process should reflect that change is possible, but never automatic. It must be earned and supported. When done responsibly, we offer not just a pathway back, but a reason to believe in something better. That, too, is public safety. Thank you, Madam Chair and members of the Legislature, for your time and consideration. I'm grateful for the Governor's confidence in forwarding my nomination. I'm committed to earning your trust and look forward to working with my colleagues on the Parole Board. I welcome your questions.
Thank you so much, Mr. Morehead, for your testimony. Now the committee will receive the written testimony from Mr. Damian M. Cartwright, the Governor's nominee to the Virgin Islands Board of Land Use Appeal. Kindly proceed, Mr. Cartwright.
Thank you. Good morning, Honorable Senator Carla Joseph, Chair of the Committee on Rules and Judiciary, all senators present, legislative staff, and the listening and viewing audience. My name is Damian Cartwright. I'm a professional engineer with over 24 years of progressive-related experience. In addition, I am also a licensed contractor. Thank you for the opportunity to present testimony in support of my nomination by Governor Albert Bryan, Jr. to be seated on the Virgin Islands Board of Land Use Appeals. Please allow me the opportunity to provide a summary of my educational and professional experience, which I feel qualifies me to contribute to this board. I graduated with a Bachelor's of Science with honors from the University of Florida in December 2000. I have practiced professional engineering for the past 2 decades, and I've also been directly working in the construction sector for the past 4 years. I hold 5 professional licenses for the practice of engineering to include the United States Virgin Islands, the state of Florida, the state of Georgia, the state of Alabama, and the Bahamas. I recently obtained my general contractor's license in the United States Virgin Islands through examination. I have designed and been directly involved in the successful construction and completion of many capital projects. During my career, I have had the pleasure of working directly with land surveyors, architects, and urban planners, which along with my related experience has given me expert insight into land use, zoning requirements, and best practices. I am truly honored and humbled to be considered for such a prestigious board that plays a pivotal role in the advancement of the territory and ensuring and protecting the interests of the general public. If my nomination is approved, I intend to contribute immediately alongside the other board members to improve and enhance efficiency and overall effectiveness. Chair Senator Carla Joseph, I thank you again for the opportunity to present details in support of my nomination for the Virgin Islands Board of Land Use Appeals. This concludes my testimony, and I am willing to answer any questions concerning this matter. Thank you.
Thank you so much, Mr. Cartwright. Colleagues, we are going to have one round of 4 minutes, and if there are any additional burning questions to the 2 gentlemen sitting here who are the governor's nominees for 2 separate boards, I will allow it. And the order of senators' questioning is as follows. Mr. Secretary Avery Lewis, Senator Clifford A. Joseph, Senator Francis Heiliger, Senator Novell E. Francis Jr., and I will be, oh, I'm sorry, I missed my Senate President. Senate President Milton E. Potter. Let me start over again. Mr. Secretary Avery L. Lewis. Then we will have Senate President Milton E. Potter, Senator Clifford A. Joseph, Senator Alma Francis Heiliger, and finally, Senator Novell E. Francis Jr. I would like to take the opportunity to welcome non-committee member Senator Novell E. Francis Jr. To the Committee on Rules and Judiciary meeting today. Thank you so much, Senator Francis Jr., for being here. So, Madam Clerk, 4 minutes on the clock. Senator Avery L. Lewis, you are recognized for your 4 minutes.
Thank you and good morning. Good morning, colleagues.
Morning.
Good morning to the testifiers.
Good morning.
Good morning.
And good morning to the people of the Virgin Islands. Gentlemen, I've reviewed your testimony, I reviewed your resume, and it come to me like I 5-star general. But anyhow, I do have to ask the important questions, but, you know, germane to the role you are here for today. First, let me say thank you for even accepting the challenge and stepping up. You know, a lot of times people want to come forward, but, you know, that's, truth be told, they kind of afraid of this institution, but I try to make it a inviting and a welcoming experience because we have to get to the bottom of this here. Mr. Morehead, good morning.
Morning.
Your first question for me would be, in your testimony, you have a lot of law enforcement and public safety experience. Can you elaborate for me a little bit on the extent of your law enforcement experience and how it will inform your decisions on the parole board?
Sure. Roy
Bring the mic
Morehead.
closer to you.
Roy Morehead. I was a law enforcement officer for 26 years, and subsequently I am on Havenside Mall as the chief of security for the past 13 years. So I've been in law enforcement, held many positions for quite a little while.
Good. So let me ask you now. Do you think by having this background, going into the parole board, with all the challenges we have, this making a parole decision isn't an easy one, not just for you, but for the community, for the victim, you know, for the families that were impacted or people who were impacted and so forth. So tell me how you know, let me know something about Roy's decision-making process, Mr. Moorehead's decision-making process.
So I think there are several factors in preparing to testify. I came up with 3 things. One is remorse, the other is risk factors, and the third is reentry readiness. I think my background supports the risk factors part of that. I think keeping our community safe, or the safety of our community and the victims, is an important process. And having been in law enforcement for some time, it's given me keen insight into keeping our community safe. And I think it's an important part of the parole process.
Good. So, Mr. Morehead, you think at some point in time, at the parole, you're kind of at the end. The crime has already been committed, the person been sentenced, they did their time. We're trying to reintroduce them back into this community. Do you think at some point in time the parole board needs to join with those individuals who's trying to stop it at the front end?
I think that the parole process is an important process of our criminal justice system. And I think that in my testimony, I talked about hope. Right? And I think hope is a big part of what I hope to bring to the board, because without hope, then those that have already been sentenced and already incarcerated, then they're sort of lost. So in terms of being a part of the process on the front end, I think it needs to be two separate pieces.
I'm not saying that it should be inclusive. I'm just saying your experience and what you're seeing in the back end, your testimonies where you're going to receive. Some people need to head on the front end so they could not make that decision moving forward.
Yes, I absolutely think,
Okay.
Yes.
Mr. Cartwright.
Time.
Madam Chair, if I just wrap up with this one here,
Yes,
please.
you may proceed,
You
Mr.
have-
Secretary.
Thank you very much, Madam Chair. Mr. Cartwright, you have more than well over 2 decades of professional engineering experience, and you're a licensed general contractor, right? Correct?
Recently, yes.
Yes, okay. How do you believe these skills that you have harnessed and you have, paid your way through college and everything, I don't know if you pay your way, but you're making through college, right? How do you think this is going to uniquely help you contribute to the Board of Land Use Appeals decision-making process?
Good morning again, Damian Cartwright. Great question. I think with my background, I think I've dealt with, just about every project I work on deals with land use development. So obviously, it's really balancing land use with all of the other nuances like development impact challenges, the adverse impacts, but also the economic benefits and the long-term benefits of it. In my background, I work closely with land surveyors and I work closely with urban planners and architects. So I have a good understanding of what's a complementary land use versus a non-complementary land use. For instance, you don't approve something industrial like a cement plant right next to a school, and the kids all of a sudden they have dust pollution, noise pollution, and they get asthma problems, right?
Yeah.
So these are the type of things that, based on my skill sets and background, like I'm already fully aware of. Now, obviously, there's a learning curve. I've never been on a board like land use appeals, so obviously there's going to be a learning process. But I always fancied myself a quick study, so hopefully I'll get up to speed quickly.
All right, my time has been called, but I'll come round for one more question for both of you, and then we'll move forward to do the appropriate thing. Thank you, Madam Chairwoman.
Thank you so much, Senator Lewis. I do have a question just to follow up, Mr. Cartwright, with the previous speaker's questioning. I understand that you have not been on this type of board, but you have been on boards before for any other organization, so you understand how they operate.
Good morning, Senator. That is correct. I'm currently on the board of architects, engineers, and land surveyors, so I'm familiar with Robert's rules and how the board processes work. But obviously, I'm not familiar with the inner workings of this particular board.
And I believe maybe some of the persons who are on that board, or any of the persons who are currently serving on that board, also serving on the Board of Land Use Appeals?
To my knowledge, 2 members.
Yes. So you already should be able to really fit well and be able to acclimate easily, because you already have persons that you've been working with who are on the Board of Land Use Appeals, who are also on this board that you're currently serving in. So I have every confidence that you'll be able to do the work. Now, Mr. Morehead, there is an elephant in the room relative to the parole board. You are cognizant that there is a lawsuit in place.
I am.
And that should you be confirmed, and I don't see any major issue why you wouldn't, you will be able to have that quorum that is required. My concern with your nomination is assuring that you have sufficient time to do the work that is required, because it plays a really critical role in someone who has been incarcerated, they've served their time, and whether or not they are ready to transition back into society. So my question is, will you have that level of time and commitment?
I do have that commitment in dedicating the time to this because, like you said, I believe this is a critical part of the process, and I think they're entitled to parole. And since we do not have a quorum, and I would make the quorum the 4th member, I am committed to making the time to make this work.
Great. Thank you so much, gentlemen, for your answering those questions. Mr. Senate President Milton Potter, you are recognized for your 4 minutes.
Thank you very much, Madam Chair. Good morning, colleagues. Special good morning to both Mr. Morehead and Mr. Cartwright. I think the governor made 2 excellent choices in your nominations for these 2 boards, I must say. I'm gonna start with my first question to both gentlemen. How would you handle potential political pressure from elected officials or community leaders in your day-to-day work on the board?
I'll go first. The parole board is one that's governed by laws, and our role is not to be political. Our role is to follow the rules of law. So I do not anticipate having a problem in drowning out the political noise. I'm here to do a job, and I hope to do it to the best of my ability.
Thank you. Mr. Cartwright?
Good morning, Senator Porter. My response to that is basically being prepared, being informed, and making the best decision that I feel with the best data available. Once I can live with my decision, that's what really matters.
Okay. Thank you very much for that. I appreciate that. You're saying the right things. Those are the responses I expect to hear, and I appreciate it. How would you, Mr. Morehead, approach high-profile cases where public opinion might influence decision-making?
Again, the parole process is pretty straightforward. And although there is a high-profile case, my colleague has said something that's very important. As long as I can live with myself and go to sleep at night knowing that I've made a sound decision, the profile of the case doesn't really matter to me.
Okay, thank you. Mr. Cartwright, what do you see as the primary challenges currently facing land use development in the USVI?
From a technical standpoint, I would say lack of informed data, lack of data to make the best decisions. And the reason I say that, based on my experience in many other jurisdictions, a lot of times we don't have the information to support the best decision for the territory. For instance, like a development impact study, an economic analysis, all of these things to really look at it, traffic analysis, etc. And I think with the utilization of artificial intelligence, I think that's something that we can now be able to look at when we evaluate certain situations that come to us. And then I think on another level, it's the issue that we have across the territory with boards as a whole, is not having a quorum to be able to make decisions, to move things along. So that's very important, to make sure that the boards have enough individuals and they're actually attending the meetings so that we can actually have a quorum to make a decision, and coming prepared to the discussion to be able to engage in what I would like the term constructive dialogue, so that we can lead to a conclusive outcome.
I appreciate that. Data has been the albatross, I think, around our neck in just about every aspect of life in the Virgin Islands, I must say. So I'm very hopeful and encouraged that you, on this board, will make some legway in that regard. Just my final question, Madam Chair. I just heard my time call, if I may.
You may proceed.
How would you balance? Thank you, Madam Chair. How would you balance economic development interests with environmental protection and community concerns?
Well, I think, first of all, I would rely on my experts. So, for instance, most developments should come with an environmental assessment report, particularly if it's in the coastal zone management. So, obviously, I would have to look at that. I would definitely draw from my own personal experience in terms of my career. And then, obviously, sometimes what's missing a lot of times, even though it is a component, particularly on the CCM side, is to demonstrate the economic impact. But a lot of times, I find that applications come through without that being properly or thoroughly delineated. But I think it's making sure that the experts provide all of the data required so that the board members can make informed decisions.
Thank you. Thank you very much, Madam Chair. At the appropriate time, I plan to vote in the affirmative for both gentlemen. I think you bring a level of competence and level-headedness to your respective roles on the Board of Parole as well as on the Board of Land Use Appeals. Thank you very much.
Thank you so much, Mr. President. I will now recognize Senator Clifford A. Joseph for your 4 minutes. Kindly proceed, Senator Joseph.
Thank you, Madam Chair, and good morning to my colleagues. Good morning to everyone in the building. Good morning to the Virgin Islands and everyone in the Virgin Islands this morning. Mr. Morehead, since you were the first one up, I'll ask you this. I too believe in second chances. How will you oversee the parolees after they're free or back on the free side of living?
So I think that supervision, strong supervision is a key to once they've been granted parole. I think there are parole officers that actually oversee and track the parolees. And if there's a violation of parole, then it has to come back to the board.
Okay, also, so okay, I guess when you become the actual member, because I'm confident too that the governor made 2 strong picks. With confident he did, and I think we're going to do the same here today. I must say that that's some of the issues, because to me, out here, most of our problem we have is enforcement. So that's like you saying, you're going to be relying on these individuals. So I just like the energy that you're going to be bringing to this board, I hope also that it could spread to the other portions of the parole to allow a smooth sail for the new free individuals on the road for their second chance anyway.
Yes.
Also, one more. You also mentioned in your testimony about difficult situation. Could you explain a difficult situation that you had to de-escalate?
So one of the situations that we've had, even in Havenside, is less fortunate. We have some less fortunates to come in the Havenside area. And, you know, I am a human being, and although these individuals are less fortunate, we don't want to just kick them off the property. So for me, it is a struggle sometimes to tell these individuals, hey, you know, we have to remove you from the property. So my goal is to get them help. My goal is to get them to the hospital if they need to get to the hospital, or call services so that they can get some help.
Okay, I got one more question for you. Okay, so as far as different roles that needed to be played to assist the individual on the second chance to be back out in society, what would you bring to the board new for us to see something different with new second chances that will be coming out?
I think technology. You know, I think we're moving in an area where technology is impacting all of our lives. So, and I'm not on the board now, but I envision using technology as a means to both track and bring some help to those who are parolees.
Okay, thank you. Mr. Cartwright, how do you plan to address the appeals on the Board of Land Appeals? Like, as of late, we heard testimony as far as last week on position on clear and defined timelines for hearings.
Yeah, good morning again. I think first and foremost, I think I just need to be prepared. I think I need to come to the meetings prepared, do my homework so I can make an informed decision. But, you know, the way I look at life is like there's no definite black and white. You know, there are always gray areas that you have to balance, you know, the benefit of the greater good over the specific challenge in front of you. And so that's how I approach it.
Madam Chair, I have one more question.
You may proceed, Senator Joseph.
Mr. Cartwright, I'm looking at your now a contractor and a busy engineer. So I listened to you also mention earlier that a key factor of a board operating is members showing up. So I'm just questioning now, how busy are you to get the time to make sure that, or
I like to say this. I had the privilege of serving under a great boss that once told me, take night and make day. So over the past few years, I've kind of learned how to do that. But what I will say is that if you look at my track record on my current board, I think over the last 4 years, I may have missed 2 to 3 meetings at the most.
okay.
So, you know, I pride myself in terms of my civil responsibility. I think it's a privilege to serve on these boards. I think it's an honor. I take it very seriously. And I think it's a civic responsibility for me to give back to the community that's been so great to me.
Thank you both for your responses. Thank you, Madam Chair.
Thank you so much for that line of questioning. Mr. Cartwright, I wanted to just follow up on a question that has been burning in my mind relative to your position on the Board of Land Use Appeals. Under a previous hat, I was a major advocate and served as a president of an environmental association in St. Thomas and St. John, where we advocated for preservation and conservation of our natural resources and our environment. So what we were trying to do, and I think we were doing a great job, was to strike that balance between conservation and preservation with development. Because we do want to see, you know, our islands go forward. So tell me, explain to me how you would ensure that both the applicant as well as the public or those persons who have actually filed, that would be whether it's a CZM applicant and the person who has filed an appeal of a CZM permit, how would you work with them to assure that they are treated fairly and respectfully?
Well, I think mindset. I think I go into every situation with the true belief that there is always a compromise and a solution that can be obtained that both parties can walk away with and feel satisfied. I think when we look at development and preserving the environment, it's a delicate balance. On one hand, we have to create the economic opportunities to keep our talented youngsters in the territory. You know, right now we are experiencing a talent and a brain drain. And the reason being is that we're not creating enough economic opportunities to keep them here. Okay, so we have to be cognizant of that. But we also have to be cognizant of preserving the environment, right? But I think when we look at development and impacts at certain sites, there's a situation where they have, like in certain other jurisdictions, you have what you call a mitigation bank system, right? Where you can go around the territory, you can identify environmental real estate that you can protect in perpetuity. It may not be exactly at where you're having the impact on the development, but you can buy credits against this mitigation bank, and you say, okay, within a certain distance of the development, we have preserved X amount of acres to offset that impact there. And they do this throughout the US, throughout different jurisdictions. I've dealt with many developments, let's say in South Florida, right, where you have the Everglades, right, which is a big environmental tract of land that you want to preserve, right? It's a major ecosystem. But they've created a system where, yes, we know that, for instance, we have the balanced development at this site, but we have some environmental impacts. But hey, we can offset that within an acceptable distance by creating this mitigation bank where we preserved probably at a factor of 2, double what we're going to impact here. And so I think those are the type of compromises that we in the territory have to look at holistically. And we don't have to reinvent the wheel. We just have to look at what other jurisdictions, there's a roadmap already to follow. And I think with the implementation of technology like artificial intelligence, it's going to help us tremendously if we're able to use it responsibly to be able to do these type of assessments, to do these type of studies, to do these type of projections so that we can make better decisions.
Okay, thank you. I mean, I really want to go to the next senator, and I'll come back to you regarding that, because I do, based on what you just said, I do have some follow-up questions surrounding what you just placed on the record, Mr. Cartwright. Senator Francis Heiliger, you are recognized for your 4 minutes.
Good day to my colleagues, good day to the people of the territory, good day to staff, good day to testifiers. My first set of questions is to Mr. Roy Morehead. First off, I would like to say thank you for taking on this task of becoming a potential member of the board. As we all know, we are dealing with a court case, and hopefully if you are confirmed, that would assist with us resolving that situation, specifically in giving individuals an opportunity to be heard. Earlier when you spoke, you talked a little bit about how would you look at potentially doing paroles. And I want to flip it a little bit. What exactly would someone have to do from your perspective for you to actually see that they are remorseful? Because, you know, you could have great actors and actresses come before you. There has to be other things or ways you could look at it to see how this person is progressing or lack thereof. What other things you potentially could zone in on that could assist with helping these individuals or not?
So, you know, the way the process works is the Bureau of Corrections provides us with a file on this particular individual that's before us. And within the file, you know, we look at certain things that would give us an indication on whether this individual is remorseful or not. But it is a difficult task. And yes, there are actors and people definitely can fool the board. But it's not just that they have to show remorse. I think remorse is a huge factor. So, you know, all I can do is trust my judgment based on the files that are in front of me and what this individual has done during his time incarcerated. Okay. One of the things that and I want your thoughts on this. One of the things that we know is that I think it's the AG is also on the parole board. Yes, as a non-voting member. Exactly. What exactly, as a non-voting member, I understand that they're there, they observe, but do you think even their presence is necessary, or you think that's something we need to look at? Because I see it from both sides. I see it where, okay, he's there to maybe share information, but also this is the same person or office that potentially might have put that person away, and there's could be some bias. What are your thoughts on that? I mean, I know you might want to stay out of the politics of it, but I really need to get an answer for that.
1 minute.
Well, I think it's difficult because I have not attended a hearing, right? So I don't know specifically what the AG's role is, but I do think having a legal mind during the hearings is important to ensure that we're following the law, you know, and making sure that everything is, all the steps that we take, all the decisions that we make are legally sound.
I agree with the legal mind. I'm still a little bit iffy on having the AG there. I want to ask Mr. Cartwright a couple of questions. Thank you for also stepping up and participating in this process, and hopefully you might be nominated. How do you gauge, because I hear you speak a lot about utilizing artificial intelligence as a way to potentially progress in this particular area and collect data. How would you, sitting on the board, could potentially assist? Could I quickly wrap up?
You may proceed, Senator.
Thank you. How could you, specifically sitting on the board, could potentially assist other board members in understanding the importance and potential use of AI in order to help advance the board and serve the public in a much more positive way?
Thank you, Senator. Well, first and foremost, AI is just a tool to achieve an outcome, from my perspective. I think I have a lot of members on the board that are very knowledgeable in terms of what the outcome need to be, in terms of what information is needed to make a better decision or an informed decision. For instance, many of the board members, two of which are on the board I'm currently with, are very familiar with economic impact studies, are very familiar with traffic analysis studies, are very familiar with development impact studies. So it's just me educating them, or us coming together and say, okay, we're going to utilize AI now to be able to spit this data out so we can make informed decisions. And not only just that, I always believe that whatever challenge we have, more than likely there's another jurisdiction that have dealt with something very similar to this. The problem is that how can you access that information in a timely fashion? Now you can use AI to run those checks for you that you probably couldn't do without, And that's basically how I see it.
Okay, thank you so much. Thank you for the additional time, Madam Chair, and I definitely support these two nominees.
Thank you so much for that last question, because that was some of the questions I wanted to ask Mr. Cartwright regarding the use and the infusion of artificial intelligence, AI, into the work of the Board of Land Use Appeals. But my question, based on your comment before, is that buyback system. I know there have been buyback or to weigh it for developers, or even when you're looking at the Clean Air Act in certain regions. And how are you seeing that is going to work for our people? We have a very small area compared to what you use as the Florida Everglades. We are not that vast or fortunate to have such a large area. And our major economy is very dependent on tourism. And so that is the crux of the issue. We are dependent on that industry, and at the same time, we want to go forward with development. And how is that going to be able to assure that we are still preserving our environment with also moving forward with development? Do you see, based on your background, that you will be able to tell and work with the applicant, who would be a CZM permit applicant, and a person who may be opposed, who could be a organization, environmental organization, or even a neighbor where this development may be happening, so that you could find a common ground, because that's what is needed, a common ground. How do you see you can work with that, or have you had any opportunities to work in that realm?
Okay, great question, Senator.
I know, because I've worked there, so I understand specifically what is going on and what you will be encountering, because I stood as an advocate.
All right. Well, I think number one, I think obtaining consensus and compromise through full transparency. I think that's where we have to start off, right? That we can't operate in silos. I think we need public input. We need all the stakeholders to be a part of that decision-making process. Relative to the economies of scale, yes, I mean, I referenced South Florida, but you know their developments are also much larger too. So it's all relative. But for instance, when I look at the mitigation bank system, right, it has to protect each individual community. And by that, what I mean is that I can't go to Puerto Rico and buy credits to offset an impact in the Virgin Islands, right? That doesn't work, okay? I can't go to St. Thomas to buy credits to offset an impact in St. John, because me as a community member of St. John, I'm gonna be highly offended by that, because that means that you're taking away all of my natural habitats and preserving them in another jurisdiction where me growing up invested in that community, I'm not going to see that benefit, right? So we are a decentralized territory, so we have to look at all that, and we have to be sensitive to all those challenges to find common ground. But yes, it can be done. At the end of the day, you know, when you look at the consensus we had, the 2010 consensus to the 2020 consensus, you know, there's a roadmap that's being painted there, right? That we're losing population, and we're using our young population. We're using our educated population. So we have to find a balance, okay? So we have to find a way that we can make responsible development work with protecting the environment.
Thank you, and that's the key word you use, responsible development. At this time, I will recognize Senator Novell E. Francis Jr. for your 4 minutes.
Thank you very much, Madam Chair. Good morning to you, my colleagues. Good morning to the nominees, as well as good morning to the people of the Virgin Islands. I first want to continue to say that my heart is heavy as I continue to see the impact that's happening over at the Gaza Strip and all of the atrocities that continue to happen to humanity over in that location. I'm hoping that we could really bring some peace to that situation. Here at the home front, I want to thank both of the nominees, Mr. Roy Morehead, who I've worked with in the past, as well as Mr. Damian Cartwright, who too I've worked with in the past, for their continued public service and being a public servant. Obviously, public service is in your DNA, and you continue to do that and do it well. So I want to thank you for your willingness to serve, and also to thank the governor for your nominations to this. I'm not a member of this committee, so I don't have a vote here, but nonetheless, I felt it important to be here to at least, just query you a little bit in terms of your decision to be on these boards. I wanted to start off with you, Mr. Morehead, because of course you have a serious responsibility to assume in terms of serving on the Virgin Islands Parole Board. Coming from a law enforcement perspective, and for me, it took a minute to change the hat, right? Before our training, just talk about arresting individuals, putting them in jail. How do you balance that in terms of how do you now change where you understand the importance of allowing for rehabilitation and reentry of these individuals and giving a second chance program?
Excellent question. I think as I've gotten, I'm going to say wiser, not older, but as I've gotten wiser, and not being in law enforcement anymore, I think my overall perspective on life has changed quite a bit. And I realize that I have kids now that are in their 20s and 30s, and we all need hope. And that's why I really chose in my testimony to end with hope. And I think it's important that just because someone has made a mistake does not necessarily mean that there is no hope. And I hope to bring that to my decision-making process.
Excellent. In terms of recidivism, because we know that based on statistics, that we see that, I know back in the days, I haven't checked the current trend, but we knew that at least 65 to 70% of the individuals that got released from prison had the tendency to go back into prison. So how do you reconcile in terms of in your decision-making process, to ensure that individuals are rehabilitated and be prepared for reentry into the community?
I
1 minute.
I think there are three things. One is We need to make sure that there's housing. We need to make sure that these individuals have some place to go that's a positive influence on them. We need to ensure that they have work. You know, it's one thing to be incarcerated, to come out on parole, and then you don't have a job. So we need to find ways to give them work. And then supervision. You know, Senator Joseph talked about, you know, how do we enforce the rules that they're under, but you know, we need to make sure that we supervise the parolees to keep them on the straight and narrow.
Very well. Thank you. Real quickly to Mr. Cartwright. Again, I wanted to ask you, how do you balance preservation with economic development? How do you see that in terms of your responsibility when you're considering you know, your role?
Time.
I think data tells you one thing, but it's like you balancing humanity with revenue generation, right? So it's one of those things where looking at a compromise, trying to find the greater good, but you have to preserve what you have damaged or what you've taken away. I fundamentally believe that mitigation is a big part of that. Like, for instance, I may not be able to keep this wetland where it's at because the benefit of this development for future generations and the impact, I could find a compromise by preserving that wetland in perpetuity in a jurisdiction or a distance away from that development that makes sense, that future generations can still enjoy and experience that habitat, okay? But it has to be relative to the community that it serves.
Very well. Thank you. Madam Chair, may I just conclude with one final question?
You may proceed.
Thank you very much, Madam Chair, for your leniency. My final question to you, Mr. Cartwright, is in respect to this body was instrumental in moving a legislation for the comprehensive land and water use plan that had been attempted for many years, many decades. You know, finally, we do have a land and water use plan, a comprehensive land and water use plan in place. What or how do you see the interconnect between the comprehensive land and water use plan in terms of your role with BLUA?
Well, I think that's a tool that it's almost like a roadmap for my board, I think, in a sense that, you know, it's kind of like the quote-unquote Bible to follow for the territory. You know, it kind of really, it's a resource that whenever we look at a particular dispute, I think we have to go back and see how it aligns with that document. So I think it's a very important tool for the Board of Land Use Appeals, in my opinion.
Very well, thank you. Again, I want to thank you for your willingness to serve, and certainly you do have my support and my vote at the next step, which would be the general session, because I don't have a vote on this committee. Thank you very much, Madam Chair, for your leniency and time.
Thank you so much, Mr. Chairman. You're usually very lenient with me, so I tend to treat others as I would like to be treated. So I do have a few questions for the both of you, and it was just the previous speaker, questioner, the senator, asked a really critical question regarding the land use plan, the land and water use plan, comprehensive land and water use plan. Mr. Cartwright, are you familiar with the plan or some of the aspects of the plan? Because you're going to be going into this board. And I'm wondering, how informed are you regarding the plan?
Sounds like a trick question, Senator.
Just a question. You could say you have a. It is up to you. Just remember, you're under oath.
I took an oath. I was just gonna say I took an oath, so I know it from a peripheral point of view. I haven't delved into it or perused it as deeply as I need to. But that is some reading up and some homework that I will definitely do before I get vested in the board, if I am confirmed. But yes, I am familiar with it at a peripheral level.
Okay, because you know, we passed the act. However, they're still putting some meat on it, and so the role that you're going to take with the Board of Land Use Appeals, I know it will be valuable, and coming with your background, I call you guys technocrats, because you're very technical. And so you will be able to hopefully strike that balance between conservation, preservation, as well as development, because given our economy, given our industry, it is a vital balance that we need to strike. Mr. Morehead, you and I had a very great conversation when we sat down, and I had a good talk with you, and I was really impressed. I'm impressed by your level of commitment, and that you seem to have a great grasp, at least, of what is needed for the parole board. Now, I have spoken to 2 of the members of the parole board, Dr. Thomas, Bentley Thomas, as well as the chairman, Howell. And based on what they told me, that you reached out to them already and you had conversations, that tells me that you're committed. End of story for me. That shows me that you're committed to this board, you're committed to do this work. And because I asked them if you had spoken to them, they said yes. Their issue is that they have a lot of work to do, and they are ready to, welcome you in and to be in a position to help get the work done. So I have a question, and it's more so philosophical. It's not necessarily something that has to do with the mechanics and the operation of the parole board. What do you consider to be the primary purpose of corrections? When you are incarcerated, what do you think it is, the purpose of it? Why do we as a people incarcerate human beings who are convicted of doing bad things?
I think there are a couple of things. One is, a factor is punishment. If you do something that is bad, there is a punishment factor. Another factor is the victims, and being able to bring some closure, some relief to the victims. And I think that those are 2 very important parts of why we incarcerate. Leave it there.
Okay. Now, this is a big question.
Sure.
Are there any crime that you think are so heinous that the offender, in your judgment, should never be paroled? I see you sitting back, because you, coming from your law enforcement background, you have seen a lot. So heinous, so egregious, that this human being should never see the light of day and never be able to come out and be surrounded by us as citizens in our community?
Senator, that's an excellent question. That's one that requires a lot of deep thought. I will answer it this way. The criminal justice system is such that, thankfully, I don't need to make that decision. It is the courts and the judges that make those decisions. My role on the parole board is to enforce what the judges have said. It is something that I would definitely need to process and think about. But right now, that's not something that I have to contend with.
So you will also look at, even if a person who comes before you and the crime, the offender, and the offense was so heinous you would take into consideration what the Bureau of Corrections has stated about the offender who is up.
Absolutely. That is, we rely on the Bureau of Corrections quite a bit because they have to prepare a case file for us. And once they prepare the case file, I mean, it talks about what they've done when they were incarcerated and possibly how remorseful they are. Again, I haven't been there, so I need to get in and take a look at what the case files look like. But yes, we rely on corrections to give us information that helps us make a decision in terms of parole.
Okay, good enough. Well done for me. Are there any other burning questions, committee members? Yes, Senator Clifford Joseph, you're recognized for a burning question.
Thank you, Madam Chair. This question is pertaining to all your questions. So if politics plays a role to a point, how fair do you feel, like in fairness as equality? Somebody gets pardoned. Two individuals does a crime. One gets pardoned. And for some reason, outside of what you mentioned, everything else is there for the other individual. Behavior is good. Parole have good reporting, but they just don't, for some reason, he's not getting paroled. I mean, I take what you said earlier about the judges making a decision, but the fairness, because if we both got trial together and you find a reason to release one, why should the other person serve out time? What's your perspective on that? Thank you for the time.
So, you know, the process is such that if you get convicted of a crime, there are guidelines of when you become eligible for parole. So if you get convicted of a crime and the crime calls for a penalty of 20 years
yes,
or 15 years, I believe you become eligible for parole after half of that time. So it is only after half of the time or whenever that the timeline is that you become eligible for parole that you would then apply for parole, come before us, and then we take a look at your record. In terms of, you know, if someone gets pardoned or other factors, I think it is important that we separate each individual because each individual has a different history. So we have to look at them on their own merits.
Again, I took it back the way you went. I just asked a question based on we both got caught doing whatever we did. I'm just being the advocate of the goat and the sheep, because I mean, all I have is I only raise boy children. So I could just tell you about, and I try and show them the same thing. Friends and companies, when you file, you file. So I just wanted to be sure that in a small community like this, and even on a large scale as well, your family ties might allow you freedom. So I'm just saying, as far as a board member, and you know to yourself, these two individuals got time for the same exact crime. You know, separation in the crime. Our time was tied together. So I want to make sure now that was time, his family got a connection, he is free, and I'm still serving time. Even time now that I met some of my prerequisites to be paroled. That's the key thing.
So I think if you're asking if both individuals are eligible for parole at the same time, and one is granted parole and the other is not, I think, again, I'm going to go back to, as a member of the board, we have to look at the individual and what they've done since they've been incarcerated. But, you know, the criminal justice system is so vast. Even once you've been arrested and there is the trial process, right? Some people may decide to plea, which would give a different sentence. So although, you know, they may have done the same thing or committed the same crime, the criminal justice process is different. So on the parole board, all I have in front of me is when is this person eligible for parole and what they've done since they've been incarcerated that would make them eligible for parole and make them a candidate for parole.
Yes, again, but I'm just showing where sometimes where the politics lay in, because that question was posed to you earlier. I just want to make sure that.
I believe, I'm
Okay,
sorry.
good. Well,
I'm
anyway,
sorry,
thank you for the
Senator
time, and I wouldn't extend
Joseph.
anymore.
I believe the nominee has answered the question based on what you asked. Senator Milton Potter, do you have a burning question?
Yes, I do, Madam Chair, and thank
Kindly
you very much for
proceed.
the opportunity. Thank you. I wanted to ask Mr. Cartwright, what role should affordable housing considerations play in land use appeals decisions? And then I have a quick question for Mr. Morehead.
All right. Good morning again. Yeah, I think that goes back to my statement in terms of serving the greater good of the community. So I think it plays a very important role. I think if you look at some of the unique challenges that we have in our territory, it plays an extremely important role. But I also know that, you know, developers are not really incentivized to build affordable housing. So that's always a balancing act, but there are incentives and there are ways to accomplish that. Again, you know, I've seen it done and I've seen it done successfully. But to answer your question, yes, it's a very important piece of the puzzle.
Okay. Thank you. And just quickly for Mr. Morehead, just to get a sense as to how your thinking will work when you're considering granting parole or voting to grant parole, what should most heavily weigh, or what would most heavily weigh in your decision-making process? I mean, is it the nature of the crime, the way the person behaved in prison, the victim impact statements, community readiness? What are the most critical factors that you personally, as a board member who's accountable for your vote, what are you considering most when you make your parole decisions?
That's an excellent question. I think it is 3 factors to consider. I think I mentioned them a little bit earlier: remorse, risk factor, and re-entry readiness. It is all 3. So I don't think any one weighs more than the other. You have to look at it holistically. You have to see whether this individual has shown remorse. What are the risk factors for granting this person parole, and whether he or she is ready to re-enter or to be paroled. And, you know, what factors outside, whether he has work, whether, you know, his housing situation, all of those things. But all 3: remorse, risk factor, and re-entry readiness.
Okay. Thank you for your response. Thank you, Madam Chair.
Thank you so much, Mr. Senate President. I hear a motion. Senator Avery Lewis, you are recognized for your motion.
Thank you, Madam Chairwoman. Madam Chairwoman, I move that Mr. Roy Morehead, the governor's nominee to the VI Parole Board, be voted upon favorably and forwarded to the full body for further consideration and action. I so move.
Second.
Second.
The motion made by Senator Avery Lewis has been moved properly and seconded by Senators Alma Francis Heiliger, Milton Potter, and myself. Roll call on the motion to favorably approve Mr. Roy Morehead to the parole board.
Senator Carla J. Joseph.
Yes.
Senator Joseph Ye. Senator Kenneth L. Gittens. Senator Kenneth L. Gittens, yay. Senator Alma Francis Heiliger.
Yes.
Senator Alma Francis Heiliger, yay. Senator Angel L. Boquez Jr. Senator Angel L. Boquez Jr. absent. Senator Clifford A. Joseph. Senator Clifford A. Joseph, yay. Senator Avery L. Lewis.
Yes.
Senator Avery L. Lewis, yay. Senator Milton E. Potter.
Yes.
Senator Milton E. Potter, yay. Madam Chair, you have 6 yeas, 1 absent.
Thank you, Madam Clerk. Mr. Roy Morehead, the governor's nominee to the Virgin Islands Parole Board, has been favorably voted upon in the Committee on Rules and Judiciary and will be forwarded to the full body for further action and consideration. Do I hear a motion?
Yes, good. Thank you again, Madam Chair.
Senator Avery Lewis, you are recognized.
Thank you, Madam Chairwoman. Madam Chairwoman, I move that Mr. Damian M. Cartwright, the governor's nominee to the Virgin Islands Board of Land Use Appeals, be voted upon favorably and forwarded to the full body for further consideration and action. I so move.
Second.
The nomination of Mr. Cartwright, Damian Cartwright, to the Board of Land Use Appeal has been properly moved by Senator Avery L. Lewis and seconded by Senator Milton E. Potter. Roll call on the nomination of Mr. Damian Cartwright.
Senator Carter J. Joseph.
Yes.
Senator Joseph, yay. Senator Kenneth L. Gittens. Senator Kenneth L. Gittens, yay. Senator Alma Francis Heiliger.
Yes.
Senator Francis Heiliger, yay. Senator Angel L. Boquez Jr. Senator Boquez Jr. absent. Senator Clifford A. Joseph. Senator Clifford A. Joseph, yay. Senator Avery L. Lewis. Senator Avery L. Lewis, yay. Senator Milton E. Potter.
Yes.
Senator Milton E. Potter, yay. Madam Chair, you have 6 yeas, 1 absent.
Thank you, Madam Clerk. The nomination of Mr. L. Damian M. Cartwright, the governor's nominee to the Virgin Islands Board of Land Use Appeal, has been favorably voted upon in the Committee on Rules and Judiciary and will be forwarded to the full body for further consideration and action. At this time, I will allow the nominees to present a 30-second closing remark, beginning with you, Mr. Roy Morehead.
Thank you very much, Senators, for your confidence. This process is humbling for me, and I appreciate the questions. Thank you for voting in the affirmative, and I commit to serving on this board with diligence. Thank you.
Thank you so much, Mr. Morehead. Mr. L. Damian Cartwright, you're recognized for your 30-second closing remarks.
Good morning again. First, I would like to thank Governor Albert Bryan Jr. For the confidence and nomination to serve on the Board of Land Use Appeals. And I would also like to thank each and every senator that voted favorably for me. And I would also like to thank the listening and viewing audience, those that stayed on to actually watch. Thank you.
Thank you so much, Mr. Cartwright, for those closing remarks. Gentlemen, you are released from your appearance before the Committee on Rules and Judiciary. The Committee on Rules and Judiciary stand in recess for 3 minutes. And we are back on the record. Madam Clerk, kindly read into the record Block 2 of today's agenda.
Block 2, 11:30 a.m. to 1 p.m. Mr. Xavier A. Acevedo, Governor's Nominee, Virgin Islands Water and Power Governing Board. Dr. Safiya George, Governor's Nominee, Virgin Islands Government Hospitals and Health Facilities Corporation Board of Directors. Madam Chair, this concludes the reading of block number 2.
Thank you so much, Madam Clerk. We have before us the Governor's Nominee for the Virgin Islands Water and Power Authority Governing Board. And joining us online is the University of the Virgin Islands President, Dr. Safiya George, who is the Governor's Nominee for the Virgin Islands Government Hospitals and Health Facilities Corporation Board. And so I would like to welcome you to the committee. And Mr. Acevedo, since you're here in person, we're going to ask you to begin. Ooh, before I jump ahead of myself, I got to swear you in. So Mr. Acevedo, as well as President George, kindly stand and raise your right hand. And at the end, you'll say, I do or I won't. Do you solemnly affirm under penalty of perjury that the testimony you will give to the committee will be the truth, the whole truth, and nothing but the truth to the best of your knowledge and belief?
I do.
Very good. Kindly have a seat. Thank you, and you could put down your hand. Mr. Acevedo, you may proceed with reading your testimony into the record.
Good morning, everyone. Chairwoman Senator Carla Joseph, Vice Chair.
One moment. Mr. Acevedo, we're not hearing you clearly. Place the mic right next to your mouth.
Good morning.
Yes, very good.
Apologies.
And be sure to speak clearly into the mic because we have our stenographers who are actually taking the recording of this proceeding. So they aren't here visibly with us here. So they're going to need to hear you clearly so we can have an accurate record.
Thank you.
You're welcome. Kindly proceed.
Good morning, everyone. Chairwoman Senator Carla Joseph, Vice Chair Senator Kenneth Gittins, members of the Committee of Rules and Judiciary, members of the 36th Legislature, and the listening and viewing audience. Thank you for the opportunity to speak here today. I would like to begin by expressing my sincere gratitude to the Governor Albert Bryan Jr. for his confidence in nominating me to serve on the governing board of the Virgin Islands Water and Power Authority. This moment is both humbling and pivotal in my journey as a dedicated servant of this community. I am Xavier Acevedo, a proud native Virgin Islander, father, successful entrepreneur of 25 years, real estate investor, retired employee of the Virgin Islands Water and Power Authority, a former union president of the Professional and Technical Employees Union. Today, I serve as the project manager of the Virgin Islands Architecture Center for Built Heritage and Crafts, where I lead impactful projects that reflect our community's values, meet funding goals, and promote lasting sustainability. Because of my deep roots in this community and my professional experience that spans every level of WAPA's operations, from labor to leadership, I bring a unique perspective. I understand stakeholder concerns, organizational culture, and operational standards. And it is my belief that I can be an invaluable asset to the governing board and a catalyst in unlocking the path of meaningful service improvement. The Virgin Islands and Power Authority is unlike any other utility in the United States. Its challenges are unique, and so too must be its solutions. Have recently retired after 20 years of dedicated service. I bring a first-hand knowledge of WAPA's inner workings. I have served as president of the P&T Union, led labor negotiations, and worked as an engineer technician, project manager, and draftsman. I have stood shoulder to shoulder with WAPA employees during hurricane restorations, outages, equipment failures, emergency repairs. I have witnessed the resilience, the sacrifices, their unwavering commitment to serve our people, often under difficult circumstances and sometimes without compensation. I also know what it takes to challenge the status quo and deliver change. I have contributed to significant shifts in resource distribution, internal management, and oversight during my career. Yet, despite the dedication of the workforce, WAPA is at its breaking point. Change is urgently needed. Over the years, some concerns of the Virgin Islanders have not been fully addressed, which has contributed to gradual decline in public confidence. One such example is estimated billing. Not so long ago, I had to explain to my own mother why her water bill had remained the same for nearly 2 years. As a former employee, I could explain the practice of estimated billing, but to her, as to many residents, it was confusing and unacceptable. This is not simply a billing issue, it is a trust issue, and one that demands immediate correction. Meaningful reform cannot happen in isolation. It requires the combined efforts of the governing board, executive management, and WAPA's dedicated employees working together to rebuild credibility across the territory. Together, these partners must promote financial stability, operational effectiveness, and customer service excellence, while safeguarding the authority's asset and maintaining the highest standards of environmental health and safety. Achieving this will depend on consistent community engagement and strong partnership with the government of the Virgin Islands. I understand that the governing board's principal responsibility include establishing policies, monitoring the utility's overall performance, hiring and evaluating executive director, and approving the appointment of other key officers. In turn, the executive director is tasked with implementing the board's policies, keeping the boards informed of the progress, manage day-to-day operations, and remain accountable for the organization's performance. My objective today is not to criticize WAPA or its workforce, but to reaffirm that I believe wholeheartedly that WAPA can be stabilized and improved. This will require decisive action, transparency, and accountability. I have both an actionable plan and practical experience to ensure it is implemented effectively, even when faced with foreseeable and unforeseeable obstacles. My goal is to address 5 immediate priorities: end back-to-back billing, improve and expand communication, revitalize the solar energy program, establish an underground utility infrastructure division, expand workforce development, and a succession plan. These priorities are not abstract ideas. They are practical steps that reflect both the immediate needs of the community and the long-term visions to transform WAPA. My commitment to this mission is not just professional, it is personal, grounded in decades of service and lifelong investment in the Virgin Islands. I have dedicated my life to public service, and that commitment has been demonstrated through both my work and my willingness to share resources for the betterment of this community. I am a man of my word, a man of conviction. If confirmed, I will devote my full-time attention, impartial perspective to this role. I will work to align the WAPA strategic plan with this urgent recommendation of the Ernst & Young Organizational Assessment Audit Report. Both documents highlight modernization, renewable energy, expansion, billing reform, and workforce investment. My focus will be transforming these priorities into measurable outcomes, clear timelines, and transparent reporting. WAPA's challenges are real and significant, but they are not insurmountable. With the right leadership and renewed accountability, we can restore trust, improve service reliability, and build a utility system that is modern, resilient, and worthy of the people of the Virgin Islands. I stand ready to serve and respectfully ask your support in confirming my nomination. I am prepared to address your questions and to demonstrate my readiness to work on behalf of this community. Respectfully submitted, Xavier Acevedo.
Thank you so much, Mr. Acevedo, for your testimony, for reading into the record your testimony. At this time, I would like to recognize Dr. Sofia George, and before I allow you to read your testimony, Dr. George, into the record, I want to make sure that the listening and viewing public is clear. This committee earlier in the year voted favorably for Dr. Safiya George to be a member of the Virgin Islands Government Hospitals and Facilities, Virgin Islands, to serve on the district governing board of the Virgin Islands Government Hospitals and Health Facilities. She is now nominated to serve on the Government Hospitals and Health Facilities Corporation Board of Directors. So there is a distinction so that everyone is clear relative to the distinction. It's now for the Virgin Islands Government Hospitals and Health Facilities Corporation Board of Directors. With that clarity so that everyone is clear regarding the two nominations, Dr. George, you may proceed with reading your testimony into the record.
Thank you, Senator Joseph. Good afternoon, Senator Joseph, Chair of the Committee on Rules and Judiciary, members of the committee, other members of the 36th Legislature present, other testifiers, members of the press, persons in the viewing and listening audiences, ladies and gentlemen, thank you. As was said, my name is Dr. Safiya George. I have the privilege of serving as president of my alma mater, University of the Virgin Islands. It's an honor to appear before this distinguished body today. As a proud native of the Virgin Islands, I'm honored to be here today again, and I'm deeply grateful for the opportunity to be considered for service on the Virgin Islands Government Hospitals and Health Facilities Corporation Board of Directors. And as was previously stated, I currently serve on the St. Thomas, St. John District Governing Board of the Virgin Islands Government Hospitals and Health Facilities Corporation. I appreciate the confidence placed in me through this nomination, and I welcome the opportunity to contribute to the vital work of strengthening healthcare governance in our territory. As president of the University of the Virgin Islands, I've dedicated my career to courageous, caring leadership, scientific research, and to transformation in healthcare. I truly believe that strong strategic leadership and collaboration are essential to improving healthcare access, quality, and sustainability in our community. Throughout my nearly 30-year career in healthcare, I've remained committed to improving patient outcomes, advancing healthcare education, and strengthening the connection between healthcare institutions and the communities they serve. My journey began right here as a nurse at Seaview Nursing Home and Rehabilitation Center, followed by years of clinical experience at the Governor Wang F. Louis Medical Center and multiple leading healthcare institutions, including Johns Hopkins University Hospital, Grady Memorial Hospital in Atlanta, Georgia, Northside Hospital, and Piedmont Medical Center in Atlanta. In addition, my early training as a nurse student at the University of the Virgin Islands provided me with hands-on experience at the Schneider Regional Medical Center and outpatient clinics on St. Croix, as well as on St. Thomas and on St. John. Beyond direct patient care, I've dedicated nearly 20 years to higher education, focusing on healthcare education and workforce development. I've served on numerous healthcare boards, including an international board representing 30,000 nurses globally, where I was an active leader for a decade. And my service also includes organizations such as Boca Helping Hands, which addresses food security, job training, and healthcare access, including primary care and behavioral health services in Palm Beach County, Florida. Additionally, as chair of the Florida Association of College of Nursing, I was part of the leadership team that successfully advocated for legislative support to expand nursing education and strengthen partnerships between universities and healthcare institutions across the state. As a health scientist, I've authored over 50 peer-reviewed publications, journal articles, and contributed to multiple book chapters. My research has focused on critical public health issues, including HIV and AIDS, sexually transmitted infections, and risk behaviors, among other things. I've also leveraged data science and machine learning to develop predictive models for COVID-19 outcomes, such as mortality risk, ICU admissions, hospital length of stay, and ventilator use, as well as developing models for predicting Alzheimer's disease and related dementias. The Virgin Islands continues to face serious health challenges that affect our families and our communities. Heart disease, cancer, homicide, and unintentional injuries remain the leading causes of death, and homicides in particular account for far too many years of life lost. Although life expectancy in the U.S. Virgin Islands has risen to nearly 79 years, the absence of updated published figures locally reminds us of the need to invest in reliable health data. For context, in 2023, the average life expectancy in the US was 78.4 years, about 4 years shorter than the 82.5-year average of other developed countries. This widening gap underscores the importance for improving local outcomes and aligning with global health standards. Data from our community health centers further illustrate areas of concern. For example, the St. Thomas East End Medical Center and Fredericks Healthcare, Inc. on St. Croix report persistently low screening rates for key conditions such as diabetes, hypertension, and cancer below ideal targets for preventative health. For example, at East End Medical Center, hypertension was prevalent where over 50% of community members are affected, leading to increased risk of stroke, heart disease, kidney failure, and amputations. And diabetes and hypertension screening remain lower than desired despite outreach efforts. For example, at the Fredericks Healthcare, Inc., that serves nearly 9,500 unique individuals per month with chronic conditions like hypertension, diabetes, and asthma. However, screening and follow-up rates have not improved in recent years. On the workforce side, shortages are putting a strain on our healthcare system. A 2024 national report found that the Virgin Islands has one of the lowest number of primary care physicians per capita in the country, and we do not yet have a medical school or residency program to grow our own pipeline. Federal data confirms this shortage. St. Thomas is designated as a health professional shortage area, or HPSA, across all three critical categories: a shortage in primary care providers, a shortage in dental providers, and a shortage in mental health providers, with high needs scores of 12, 16, and 13 respectively. St. Thomas also remains formally recognized as a medically underserved area, highlighting how difficult it is for residents to access even basic care. Nursing shortages continue to be a pressing concern, driven by high turnover, non-competitive salaries, and difficult working environments that include infrastructure issues, lack of supplies, and even water and HVAC challenges. The recent water contamination crisis on St. Croix, leading to emergency-led screening clinics at both St. Thomas East End Medical Center and the Fredericks Healthcare, revealed how fragile our systems can be in the face of acute public health threats. Taken together, these challenges show how essential it is to strengthen our workforce, support our nurses and physicians, and invest in preventive screening and healthcare infrastructure to meet the needs of our people. Besides my PhD in nursing research, I have several certifications and nationally recognized credentials in the healthcare industry. I have an advanced practice registered nurse board certification. I'm also a fellow of the American Academy of Nursing, a prestigious honor recognizing individuals across the globe and in the US for their outstanding contributions to the nursing profession. I'm also a fellow of the National Academies of Practice, an honor that recognizes outstanding interdisciplinary collaborations and contributions to healthcare. I'm also a fellow of the American Academy of Nurse Practitioners. With this breadth of depth of experience in both healthcare and education, I am eager to bring my expertise to the Virgin Islands government, hospitals, and healthcare facilities corporation board of directors. And I look forward to contributing to efforts that enhance healthcare access, healthcare quality, and innovation in the Virgin Islands. So I thank you for the opportunity to be here before you today. And of course, I welcome any questions you may have. Thank you, Madam Chair.
Thank you so much, Dr. George, for your testimony. Colleagues, we will begin questioning the testifiers with one round of 4 minutes. And after that round, should colleagues, you have any other burning questions, you will be recognized for those burning questions. We'll start off with Mr. Secretary Avery Lewis. You are recognized for your 4 minutes of questioning.
Thank you, Madam Chairwoman.
Good morning. Good morning.
Oh, we do this again. Good morning.
Morning.
Good morning.
Good morning, testifiers. Good morning, colleagues. Good morning, people of the Virgin Islands. Dr. George is like a senior every day now.
Here for the people.
That's right. Mr. Acevedo, I pronounce that correctly?
Correct, yeah.
Good. Let's have I know you're going on the board, right? And you're going to have a lot of roles and responsibilities and everything. And, you know, with your extensive background and your years of experience, I see, you know, you prepared yourself for this mission. But you you open up in a manner that I'd like to hear, because you had to explain your mom what a billing issue. So help me to explain to my mom about a billing issue and how you plan to correct it or assist in the correction of it. Because my mom does forever ask me, if explain this bill to me. Explain why I can't keep running this water so I could get clear water, this brown water. Explain that to me. I mean, help me to help the people of the Virgin Islands to understand my vote today, we're putting you on this board, what it means to the people of the Virgin Islands.
Keeping everyone informed, you know. My mom, she see the bill, she paid, but she said, Sabiel, why?
My mother too, she get scared.
Why the bill is the same $30? And I said, well, mommy, you know, you ain't got enough meter readers, the meter service right now. They're doing digital reading and they're trying to figure it out. She said, I don't understand. I said, mommy, I'll deal with it. Go in the office, talk to the ladies in the office, do our report, they send people back. How I will change, or how I will suggest change to the board so the director could implement it, more meter reader, getting people foot on the ground so people could see WAPA again. You understand? Because right now, nobody don't really see WAPA for the most part, so you don't know if work is getting done. So having that WAPA presence in the community again, I think is a big part of it. You know, just having that trust of my bill it is because I saw somebody come read it. So I think just having more people on the ground will be an effective change, and have upgrading the system, which that they're working on it right now from my information.
You know, I hear your response. You know, I can't kill you for your response, but I think that we need to be able to get people out there or in the offices that one answers the phone.
Definitely.
Return the calls of the consumers.
Agreed.
Customers. You know, and just relate to them. Go through the bill step by step. You know, can't talk to them with this heap of jargon like we understand. The people them need to be clear.
Simplify it.
Thank you. At least you feeling the pain.
The unique thing of our
my mother been paying, not cutting you off, sorry. My mother been paying a bill so much till it coming back till a negative. I said, Mommy, they have a credit for you now. Because she gets scared when she see these large numbers. And I know many others are doing it. They have to stop. Every time I talk to somebody in there, we fixing the billing issue, we fixing the billing issue, we going to this program. It ain't working, something need to get rid of and change over.
30 seconds.
Stop right there. Dr. George, I'm coming to you with the same question. As we sit here in this body, we see that the both hospitals at times have billing issues. How do you feel we could remedy this? I went to the emergency room in December, just got the bill here in June, or whatever, with May or June. Please help me to help the community. Thank you.
Time.
No, you're going to answer. Thank you.
Thank you, sir. No, you're correct. I think that I haven't been to Wang Louis Hospital recently, but I have been there in the past. And I do think that the hospital.
Dr. George, I know where you are, but you have to speak a little louder because we could barely hear you.
Oh, sorry. Especially from Schneider Regional Medical Center, I think online payments is something that I saw in a recent bill because I took my son to the emergency room not too long ago and got the bill afterwards. And there's no way to pay online. The bill says, come into the office to pay. We still have very antiquated forms of paying bills or call a certain number. And as has been said, you know, we also need to make sure that people are available to answer phones regularly. So I think in order to help hospitals improve collections, there needs to be a way for rapid payments, for online payment portals so that people can pay their bills. Because people like myself, like you, we want to pay our bills and our balances. And so that's also delayed or lost revenues for those hospitals. So I do think better billing options, more user-friendly billing options are key as one example.
Madam Chair, if I may wrap up with one more question, please.
You may proceed.
Dr. George.
Yes, sir.
You're our nominee today for Government Hospitals and Health Facilities Corporation Board of Directors. There's this belief, I'm going to say belief, or in the community that our institutions do not provide optimal health care. As a board member or, being part of the institution, and because of your degree, your background, and even as a president of university, what do you think could happen to try to regain that trust? I think we have to take it in small nuggets, but I may be wrong, but I'll yield to your professional answer. But break it in a way that the community understands, please. It's a community we're speaking to, not every with a masters or whatever. We're speaking to the community today. Thank you.
Yes, great question, sir. I do think that the current boards of those hospitals are trying to do their best due diligence to get their hands around the state of each of the hospitals, Wanglui Hospital and Schneider Regional Medical Center. And so the monthly regular meetings that happen on those boards of, sharing the financial data, sharing the healthcare outcomes data, and then deciding how much of that data can be shared publicly, right? In digestible ways for the community, whether it's health outcomes data, or info briefs, or information about what the community can do to prevent hospitalizations, right? Making sure they're following up with their preventative screening, et cetera. So I do think some more community public outreach, public service messages could be helpful to help provide information to the public, as well as increase trust from our community in two of our local hospitals as well as our clinics. So I do think that's going to have to happen in collaboration and partnership. I do think that both of our CEOs are mindful of the perceptions that are out in the community. I recently met with Ms. Baptiste for the Wanglui Hospital, or the new CEO, and I think she's doing a great job of trying to get Wanglui Hospital back on track. And so there's a lot of work that needs to be done, but I do think with the board members working very collaboratively with all of the hospital staff and with the Department of Health more broadly to help inform the community is going to be key.
Madam Chairwoman, I thank you for the flexibility. Thank you, testifiers, for your responses. And also, just to tell the C-suite and those in charge, have more regular meetings with the staff. Get their input, get their buy-in, talk with the troops on the ground. Thank you.
Thank you so much, Mr. Secretary. I do have a burning question to ask you, Mr. Acevedo, relative to your position that you are hopefully will be nominated to for the Water and Power Governing Board. How do you see, because we're talking real bread and butter issues for our people, how do you see your background coming from working at WAPA for over 20 years can be utilized to really help us get to that place where we have reliable and affordable energy? Because in St. Thomas, I understand we had a power outage, and a lot of our businesses are suffering. That's one of the real barriers, real life barriers that we're encountering in growing and expanding our economic footprint here in the Virgin Islands to have businesses come. A lot of our small businesses, especially, small businesses are the lifeblood of our economy, or any economy. And they are suffering because a lot of their equipment that they have spent thousands of dollars is getting damaged. Some cannot be repaired. What do you think can happen, you along with your other board members, to influence policies to help us reach that that level of confidence that we can give to our business community members?
That's a great question. Thank you. I think I offer the employee perspective, you know, being there for 20 years, having the trust and the knowledge of WAPA inner workings. It'll be hard to put a wool over my eye when certain projects come up. Right now, just being nominated, I got calls from certain employees just congratulating me and ready to just let me know what situations or what problems needs to be addressed immediately. So I think having someone in the board where I used to be a WAPA employee, you know, I used to be with them, I could offer a perspective where they could trust, you know, I have the experience of being a WAPA employee. Anybody could be an engineer, but to be a WAPA engineer, you have to walk WAPA. The obstacles that WAPA always faces is unique. Like you said, power outages in St. Thomas, but St. Croix is okay. So you understand? So we have to deal with 2 power plants. So the situation is always different, and you have to deal with it heads on. And that's one thing I love about the WAPA employees. During a hurricane, during major outages, everybody comes together. They make sure the works get done. But we do need that after the works get done, they follow up. They make sure everything is correct. The machines are working correct. Everyone is maintained. When last the machines got inspected, when last the poles got inspected, just a more of a check and balances situation to make sure WAPA stays on track.
Thank you for that. I also, because you mentioned you've been in communication with some of the WAPA employees, your former coworkers. What is their morale? What is the morale right now at WAPA?
I think the morale right now in the Virgin Islands is low.
Just WAPA.
It's low.
It's low.
It's low.
From 1 to 10. Based on your conversations with them, because I know you've been keeping in contact with them based on what you just said.
It's low, 6, 7, you know, like everyone gets the works done. They wish they had a little more equipment, a little more help, but I don't think no one is drastically boycotting WAPA right now, but definitely morale is low. They wish they had a little better compensation. I know money is a big issue. Promotion is a big issue. So morale is low, but I don't think it will stay like that, you know. I think they have right leadership right now.
Thank you. And I'm sure next, one of my other colleagues is going to ask, how do you think you can increase the morale? What mechanism do you think will help increase the morale with the WAPA employees? Senator Milton Potter, you are recognized for your 4 minutes.
Thank you so very much, Madam Chair. Good afternoon, colleagues. Special good afternoon to you, Mr. Acevedo, as well as Dr. Safiya George. I wanted to start with you, Mr. Acevedo, and thank you first of all for agreeing to serve in this very, very important position to both you and Dr. George. During your 20 years at WAPA, what specific systemic issues did you observe that board oversight failed to address? You've been there for 20 years. And just from your perspective, what were some specific systemic issues that you observed that the board failed to address, or board oversight failed to address?
I think the promotion, just when it's time for promotion, it was just really hard to kind of move upwards in the company when I was there. So I know I always had a problem with like just applying for promotions and just being underqualified in degrees, but I had all the experiences. So I was doing the job already, so I always felt like I should have been a manager at some point. But I think the succession plan and just upgrading people to the right position has always been a problem for me personally.
Yes. So as a union personnel on the board, how will that union background affect your ability to address these types of difficult workforce management challenges that you just explained?
Right now, one thing I was suggesting is right now they have a scholarship for engineers, but I was hoping they could get a scholarship for electricians, more supervisors, and just have a system of if they do the work, they get promoted. If they have the years experience and they're the best qualified, they get the job. So really pushing that issue that whoever is the best qualified person does the work.
A more fair, organized, predictable system for encouraging promotion.
Correct.
I can respect that. You said you wanted to see a WAPA undergrounding division, something of the sorts, which makes sense to me. But what technical expertise does WAPA currently lack for this undergrounding systems management?
Right now it's just training and equipment, as establishing the department. Right now they are in works. I had a conversation with the director, the CEO, Carl Knight, and I asked certain questions about the underground department, vendors, solar power.
1 minute.
And he did assure me that that's one of his main priorities, setting up an underground department where we could start planning for the future and having an underground Virgin Islands. So quicker, when it's time after the hurricane, we restore power way faster, you know.
Thank you for your response. I appreciate that. Dr. George, good afternoon to you. And I also want to thank you very much for agreeing to serve on this very important post. But given your research background in predictive modeling, how would you apply data science to improve healthcare outcomes in the U.S. Virgin Islands?
Great question, Senator Potter, and good afternoon to you. I think, you know, as we build trust across our board, and of course, I'm one of the newest members of the board, the current St. Thomas, St. John District Board, and I would, of course, be the newest member of the you know, the territory-wide board, is leveraging the data that we have. And I think what also needs to happen is looking at data from both hospitals, as well as data from our clinics, our federally qualified health centers, and, you know, creating a data repository. Of course, it'll be very, you know, protected, limited access, but we would need all the data that we have available to be able to build those predictive models. And I think, honestly, also leveraging the expertise in data science at the University of the Virgin Islands, right? We have an Eastern Caribbean Center, which has several data scientists who are doing this type of work at the university, as well as, you know, working with the local Food and Farm Council. But I think leveraging that expertise to work with the Department of Health, both hospitals and all clinics, to create a data repository to then build those predictive models for readmissions, for length of stay, for all of the main outcomes that we have issues with. Stroke, mortality from stroke is a big issue in the territory. So we can build predictive models for whatever is important and identifying those outcomes that, as a board, the hospital leaders, senators, whomever, whichever outcomes that we want to know about, we can predict those outcomes. So it would be a huge benefit to the community, to the legislature, to the hospital leaders, to many.
I love that idea. I love that idea. And your role on the board should make that process feasible, workable. Madam Chair, if I may just squeeze in one quick final question. I know my time has been called.
You may wrap up, Senator.
Thank you. Thank you very much. Dr. George, what specific steps would you recommend to address the nursing shortage and improve nursing retention? I know this is a specific strength of yours as a former nursing administrator, as a nurse yourself. What are we missing? What specific steps would you recommend to address the nursing shortage and improve retention in your role on the board?
Great question. I think employee education assistance programs, of course, are key, right? Because nurses already have degrees, so they don't qualify for the Virgin Islands education, higher education scholarship, the free tuition program. So I think the hospitals and the clinics would have to look at what their employee education scholarship programs look like to retain nurses. I think we do a good job, honestly, here of graduates from UVI staying in the territory. So I don't think they're the ones that we're really losing. I think a lot of the nurses in the territory that we're losing to other big hospitals on the mainland, to travel nursing. That's how and when I left. But I think one of the main reasons we're losing nurses is because they need to go and either get a master's degree. I know some of it you can do online, but for some nursing degrees, you can't do it online, because if you want to become a nurse practitioner, nurse anesthetist, nurse midwife, any of those, you need hands-on clinical training and you have to be in person. And so, if we have, UVI is working on creating master's programs so we don't lose the nurses in the territory who want master's degrees. But we also need to figure out how best to help those students stay in the territory and pay for those degrees so that they stay at the hospitals and clinics where they're working. So looking at scholarship programs, but also some states have tax benefits for, some healthcare workers, whether for nurses or for firefighters, for example, for the, emergency healthcare providers. So looking at some of those incentives that would, incentivize nurses to stay in the territory, I think is something to look at. Also continue to look at the pay and how it compares to other states and territories is key, because, right, the main reason people would leave is also because of, pay, compensation, and economics. So.
Absolutely. Thank you very much for your responses. Thank you very much, Madam Chair, for your generosity.
Thank you so much, Senator Potter, Mr. President. At this time, the chair will recognize Senator Clifford Joseph Sr. for your 4 minutes.
Thank you, Madam Chair, and good afternoon. Good afternoon to not the testifier, but the governor nominees. Mr. Acevedo, what will you consider the 3 most priorities that you think, being a board member, that the WAPA board should be addressing?
Could you repeat the question, sorry about that.
What do you see as the top 3 priorities that the board needs to address in the short and long term?
Back-to-back billing, improve communication. Back-to-back billing, improve communication, and promotion.
Okay. Having worked at the authority, what are your thoughts on the ability of WAPA's management, the management team you have right now, versus a private management team?
I'm not for private at all. I think the WAPA that we do have is fixable. I haven't worked with the newest administration, the CEOs. When I retired, it was Andy Smith. I think we could turn it around. So right now, I'm not for privatizing WAPA.
Good enough. Okay, and for you personally, what unique perspective do you think you would bring to this board?
I think my years of experience, just being an employee, being a union president, again, just being in the fight for the WAPA employees, I don't think it's going to change because I'm a board member. I just know my responsibility is going to be a little different, kind of telling the boss what to do now instead of they telling me what to do.
Okay, and how would you balance this, the constant pressure of the community and the politician pressure when making decisions on the board?
I go make informed decision. I doing it for the better of my community. So I'm not doing anything that's gonna set our people back. I definitely want to move forward, be a better Virgin Islanders, and I think WAPA could really turn around. So again, I think I see the future. I see the light.
So, and what's your take on renewable energy and reliable?
I think it's needed, but I don't think it's will the end all be all. I think we still need fossil fuel, but renewable energy is definitely a factor that could bring effective change to our WAPA system.
Effective change in?
Lower rates, especially if it's done right. If we start a program where we could do private roofs, WAPA solar panels type of situation. Again, just having more solar panels out there to be less reliant on fossil fuel. But again, we are in a hurricane zone, so
got to protect them as well.
Yeah, so we got.
Well, thank you for your response.
Thank you.
Dr. Safiya George. My question, I don't have much questions for you, but I do have a solid question, which would be your thoughts and the ability of us to integrate our both hospital to share costs and personnel resources, and providing a quality health care to the Bordenals.
I've heard, great question. I've heard this topic come up a number of times from various members of the community. And I think that's a possibility. I honestly, at this juncture, don't have sufficient level of detailed knowledge as to all I would need to know about Juan Luis, finances, operations, health outcomes, etc. My main concern is that Juan Luis Hospital is not accredited by the Joint Commission, unlike Schneider Regional Medical Center, which is accredited by the Joint Commission. So that is an issue.
That's an issue.
And if a hospital isn't accredited, it's for some significant reasons why it's not. And so there's a lot of work to be done. And I think there are a lot of lessons that could be learned from each of the hospitals. Okay. Some positive lessons that can be learned in terms of outcomes and finances from Juan Luis that Schneider Regional Medical Center can learn from, and vice versa. So I think definitely sharing a lot of information is key to then seeing what needs to be done, whether it's merging or sharing resources. But at this juncture, I don't have enough information. But that's a possibility.
Thank you for your response. Thank you, Madam Chair, for the time.
Thank you so much, Senator Joseph, for your line of questioning. I wanted to jump in and ask you, Dr. George, I know in your testimony you said something that is very critical relative to a large population of our people have not been able to, that we have one of the lowest number of primary care physicians per capita in the country, and we do not yet have a medical school or residency program to grow our own pipeline. I mean, that's a very riveting statement, knowing that we do have a large population of persons who are hypertension diagnosed, also those with diabetes and diagnosis. So how do you see the wealth of knowledge that you have, as well as your leadership position at the University of the Virgin Islands, going to be able to provide some key areas to address this lowest number of primary care physicians, your position at the university? How do you see that all working in conjunction to address this issue?
Great question, Madam Chair. As I said, we have significant healthcare provider shortage deficits in the territory for primary care, as well as for behavioral health or mental health, and for dental health. And that then ends up with the numbers that we see in terms of morbidity and mortality for heart disease, stroke, diabetes, amputations, which is getting your limbs cut off, essentially, your legs cut off. And so I do think that we definitely and desperately need a medical school in the territory. I know anyone who's talked to me has heard me mention that. The university has been on this mission for many years now, because even people before me recognize that that is something that we need. We need people trained in the Virgin Islands in medical education so that they can practice here, and we also need residency programs at both hospitals so that we can have doctors who train here, so that at least a percentage of them will stay here and understand the local context, some of whom will be Virgin Islanders and some who will make the Virgin Islands their home. So I think that is one way to help address the physician shortage that we see here. We're doing our part as a university to address the nursing shortage by continuing to prepare nurses that enter the workforce. We're hoping to be able to start a medical school and start enrolling by fall 2027. The needs for medical education are vast in the Caribbean and in the US. And I know some folks also ask about, there was a medical school started in the BVI recently. There's still a need for training medical doctors. So despite that, there's still a huge need to be able to train qualified physicians for the territory as well as for the region. So that's what we're working on very diligently, Senator Joseph, and we're hoping to be able to help address this shortage that we see in our community for nurses as well as for physicians. And when we talk about behavioral health, mental health is key. I don't think anyone will argue with that. And so when we talk about training physicians, yes, for primary care, but also training psychiatrists and also training psychiatric mental health nurse practitioners to help address the mental health issues that we see right here in our community will be key.
Thank you so much, Dr. George, for that comprehensive response. Senator Alma Francis Heiliger, you are recognized for your 4 minutes.
Thank you. Good afternoon once again to my colleagues, to the people of the territory. Good afternoon to the testifiers and staff. First, I'm going to start with Mr. Acevedo. My first set of questions have to do, earlier in your testimony, you spoke a little bit about stating that you did not want for the privatization of WAPA. The water aspect of water and power authority. The water aspect of WAPA is basically completely controlled by 7 Cs. Would you consider that aspect already privatized, or you look at that? How do you look at that?
A lot of the infrastructure of WAPA right now is outsourced, and that's something I would like to definitely look at and change. I think our people could do the work. We don't need someone coming in and doing the work for us. Just finding a plan to phase them out and kind of bring back our water plant and bringing back the right generators.
So from being on the board, your perspective is for us to ultimately phase out any other private entities and focus on our local company, water and power, being the source, reliable business to produce water and power in the territory.
I worked at WAPA when we did it all on our own, so I don't think we can do it again. So definitely a WAPA that's local. Again, there's no reason why we can't ask for help and bring in companies to make sure we have a reliable utility, but to have them full-time and doing all the work, definitely something we need to look at.
You're more like them stepping in to help, and then you guys continue
train
your own.
Learn what they bring into the table, and then definitely continue it on our own. I think that's been a problem in the past where we got all these technologies, and then the people leave, and then there's nobody to upkeep it. So
ball is dropped. Understood. It's a good thing. I've always found it's a good thing when you have someone that is involved with the masses, as yourself as an employee, to now sit on the board, because you come with a wealth of knowledge and understanding that, many of the board members might not even come close to having. So being on the board, what specific thing that you believe that would make you unique in your approach to not only making the board a better place to be, but also what influence do you think you could have in making WAPA as a whole a better organization?
I think that I just recently worked at WAPA. The information is still fresh. It's not like it's been 10 years, 15 years, and I think I know WAPA. I've been there 3 years ago working. Left projects ongoing to follow my personal endeavors, but definitely I still have my heart at WAPA, and I want to see it do better.
Okay. Dr. George, how are you?
Good day, Senator Heiliger.
Good. As it relates to this particular board, I want to find out specifically the hospitals. I was having a conversation with individuals that were having some major concerns with specifically the Juan Louis Hospital in the District of St. Croix. And being a member of this board, you're going to have unique differences that might come about with one set of dealing with one health situations in one district versus the other. How do you make sure, could I wrap up, Madam Chair?
You may proceed to wrap up. Conclude your. You may proceed, Senator Francis Heiliger.
How do you make sure, Dr. George, that you are always in a situation where you look at them uniquely so that you could do what's best for each district? Because, you know, technically we are one Virgin Islands, but at the end of the day, there are unique situations depending on the districts. How do you think you'll be able to handle situations?
I think I'll handle it similar to I handle our one UVI with two campuses, right? One in St. Croix and one in St. Thomas, where, yes, we're one territory, but there are unique considerations for each island and stakeholders on each island. So similarly, there are some unique differences in how Juan Louis Hospital operates and how Schneider Regional Medical Center operates. But I think in terms of the conditions that each hospital sees, they're similar across the territory and similar to like hospitals. So I think it's a matter of, I'm a data geek. So looking at the data, looking at the trends, looking at honestly feedback also from patients and their family members. What are the patients and family members of each hospital saying are the things that they're concerned about? What are staff saying? What are management saying? What are the outcomes that we're seeing, right? Every hospital has to measure a plethora of different metrics and outcomes. So looking at all of the data and letting the data speak so that we can see what's best, the best approach for each district, as well as, in some cases, what are some things that we can, use across both districts to, standardize. Okay. There might be some opportunities to standardize some things while some things remain unique.
Okay. Well, thank you, Madam Chair, for the additional time, and I definitely support these two nominations.
Thank you so much, Senator Francis Heiliger, for your line of questioning. Madam Clerk, kindly place 4 minutes on the clock for me. I want to also chime in with my colleagues in commending the governor for sending out your nomination, Mr. Acevedo, of course. Dr. Safiya George, your nomination to the Government Hospital and Health Facilities Corporation's Board of Directors. We have an issue here, Mr. Acevedo, this question, and I asked you about it, which is growing our economy. Recently, the Insular Territories had a meeting. The governor was part of it with some of the bigger heads in Washington, D.C. regarding our energy crisis, because it is a crisis if we can't provide reliable, affordable energy to grow our economy. We are looking at diversifying our energy source, which includes the renewable energy. How do you see, or how can you work with your other colleagues when you are placed on this board to assure that we are still moving forward to that end goal and, no pun intended, that light at the end of the tunnel, to assure that we are providing our people with affordable and reliable energy. And also, I think more importantly, that our people can trust, because I serve on the Public Services Commission. And a lot of our ratepayers don't trust the Water and Power Authority. I'm sure that's why your mother was questioning you about the bill. They don't trust it. They see that they're being billed even, and they're estimating and their bills, not necessarily billing them for the cost of their consumption, but is estimating. How can you work with your other team members on the board as well as the WAPA WAPA employees to assure that we're moving forward quickly to do that, to get the estimating of the bills them out of the way and to build that public trust?
Right now, WAPA need at least 400 to 500 million to come out the hole. I think keeping everybody informed, keeping the information simple enough that everyone can understand where we at. You know, it's not going to be an isolated situation where one person fix WAPA. It's going to take all of us. It's going to take the senators. It's going to take the government. It's going to take the community to be part of this solution. Again, finding unique ways to bring income to WAPA is going to be key. If we have to invest in real estate, again, we're semi-autonomous. We could invest in different generating income. So just finding, again, I have different perspective. So I just hoping that my youth and my ability to kind of see the world in a different light, be able to convince my board members to kind of, let me do it this way, whichever way I hoping is the right way always. So yeah, I just hoping my youth and my experience will always be a guiding light for the board members.
Okay, thank you so much for your response. Dr. George, I asked you a question earlier regarding where you see that, this big vision that we have, which I think is attainable for a university hospital, can happen. But tell us, for just the short term, because that's a long-term vision, where do you see that your position on this hospitals and health facilities corporation, how can you work along with the other members to assure that we are increasing and expanding the quality of healthcare services we offer here in the Virgin Islands for both hospitals as well as the clinics that we have?
Yes, thank you for the question. I always go back to data, but I also think it was very good that I saw that previous board members also visited in Florida, for example, to learn lessons there. I think that's important to do. I think looking at each hospital's outcomes data and comparing that to other hospitals in other states is important so that we can benchmark ourselves and see how we're really doing, right? Take a very close, critical look at ourselves in terms of healthcare outcomes and our financial sustainability. So I do think that collectively looking at where we are, coming up with a good plan of where we need to go and details and strategies about how to get there is important. And so I think that will be important. I look forward to also, looking at it from a territory-wide perspective, because as you know, I've been only working currently with the St. Thomas, St. John district. And so my answer always goes back to data, looking at the data very critically to see where we are, where we need to be. And I think once we do that, we can come up with a plan of how we get there, including how to better, collect outstanding payments, collections, how to better collect co-pays. I think there's room for improvement there. At most hospitals, at the point at which you come to a clinic or a hospital is at the point when you need to pay that copay. And if not, there's a payment plan that needs to happen. I don't see that happening here in my own personal experiences engaging with those hospitals. So I think there's room for improvement. I do think that some improvements are currently being made. I don't want to downplay that, but I do think that with a strong board and with, open minds from the leadership as well as from board members. And the board members that I've worked with so far in the St. Thomas District are very committed. And so I think we can do better because our community does deserve better and needs better. So.
Thank you so much, Dr. George, for that response. I want to leave with one question, and it's a question I always ask all of our nominees. Do you, Dr. George, believe you will have sufficient time to work on the government's hospital and health facilities corporation board of directors?
So I will say this. I don't take board positions very lightly. And when I was nominated for this, I took this opportunity because I am completely and wholeheartedly invested into the health of this community, which includes the health of my employees, the health of residents, health of visitors. I think it's critically important as a leader of this community for me to invest my time in this endeavor. And so because of that, I've set aside and committed to be able to do it. And I have the support of my UVI board to participate in this endeavor. So.
Good. I'm glad that the UVI board is supportive of you. Mr. Acevedo, I'll ask you the same question. Do you have the time? Because we confirmed, I think about 2 years ago, a young person, he's brilliant, but after about 2 years, he's gone. And so we want to be assured. I know things happen in life. Life happens sometimes and you have to pivot. But are you committed today, knowing all that the facets that you have going on in your life, to working with a board and being present, not absent, present at the board meetings to be able to deliberate?
I want to be here. Just know, as a Virgin Islander, I have to pay a WAPA bill. I can't. So I want the WAPA bill to be lower. I pay my own, I pay my mother own, I pay my uncle own. So it's 3 WAPA bills I don't get every month. So I want to be part of the solution. I will be part of the solution. I'm here right now to be part of it. So yes, I will have time, make time.
And thank you both for your responses. Colleagues, do you have any other burning questions? Any other burning questions?
Motion.
Hearing none. Senator Avery Lewis, you're recognized for your motion.
Thank you, Madam Chairwoman. Madam Chairwoman, I move that Mr. Xavier A. Acevedo, Governor's nominee for the Virgin Islands Water and Power Governing Board, WAPA, be voted on favorably and forwarded to the full body for further consideration and action. Be voted on favorably upon, in this committee and forwarded to the full body for further consideration and action. I so move.
Second. Roll call. Properly moved by Senator Avery L. Lewis, seconded by Senator Carla Joseph and Alma Francis Heiliger. Roll call on the governor's nominee, Mr. Xavier Acevedo, to the Virgin Islands Water and Power Authority Governing Board.
Senator Carla J. Joseph?
Yes.
Senator Carla Jo Joseph, yes. Senator Kenneth L. Gittins. Senator Gittins, yes. Senator Alma Francis Halliger.
Yes.
Senator Francis Halliger, yes. Senator Angel L. Bocas Jr., absent. Senator Clifford A. Joseph. Yes. Senator Clifford A. Joseph, yes. Senator Avery L. Lewis. Senator Lewis, yes. Senator Milton E. Potter.
Yes.
Senator Potter, yes. Madam Chair, we have 6 yes and 1 absent.
Thank you so much, Madam Clerk. The Governor's nominee to the Virgin Islands Water and Power Authority Governing Board, Mr. Xavier A. Acevedo, has been voted upon favorably in the Committee on Rules and Judiciary and will be forwarded to the full body for further consideration and action.
Thank you.
Thank you. Motion.
Motion. Madam Chairwoman.
Senator Avery L. Lewis, you are recognized for your motion.
Thank you. Madam Chairwoman, I move that Dr. Sofia George, the Governor's nominee for the Virgin Islands Government Hospitals and Health Facilities Corporation Board of Directors, be voted upon favorably in the Committee of Rules and Judiciary and forwarded to the full body for further consideration and action. I so move.
Second.
Second.
The motion has been properly made by Senator Avery Lewis and seconded by Senators Joseph, Potter, and Francis Heiliger to favorably vote on the nomination of Dr. Safiya George to the Virgin Islands Government Hospitals and Health Facilities Corporation Board of Directors. Roll call on the motion.
Senator Carla J. Joseph.
Yes.
Senator Carla J. Joseph, yes. Senator Kenneth L. Gittins. Senator Gittins, yes. Senator Alma Francis Halliger.
Yes.
Senator Francis Halliger, yes. Senator Angel L. Bogus Jr., absent. Senator Clifford A. Joseph. Yes. Senator Clifford A. Joseph, yes. Senator Avery L. Lewis. Yes. Senator Lewis, yes. Senator Milton E. Potter.
Yes.
Senator Potter, yes. Madam Chair, 6 yes and 1 absent.
Thank you, Madam Clerk. The nomination of Ms. Dr. Safiya George to the Virgin Islands Government Hospitals and Health Facilities Corporation Board has been favorably approved in this committee and will be forwarded to the full body for further consideration and action. Colleagues, I want to thank you for your vote. At this time, we will ask the nominees to present a 30-second closing remark. Beginning with Mr. Acevedo. Mr. Acevedo, you're recognized.
Good afternoon, everyone. Again, just want to thank everybody for the time, and I want to thank the Governor, Albert Bryan Jr., for his confidence in nominating me. Thank you.
Thank you, Mr. Acevedo. Dr. George, you're recognized for your 30-second closing remarks.
I'd like to thank the committee for their thoughtful questions and for the opportunity to be considered to serve on this board and for their votes. I also like to thank the governor for his nomination. I'd also like to thank the people of the Virgin Islands for their trust. And if I am confirmed favorably by the full board, I will do my best to serve both districts in my best interests and the interest of the entire VI community in terms of health outcomes for all. Thank you.
And thank you so much, Dr. George, for your closing remark. At this time, both nominees, Mr. Acevedo as well as Dr. Safiya George, you are released from your testimony before the Committee on Rules and Judiciary. The Committee on Rules and Judiciary stand in recess for 1 hour. And we will be back on the record. Let me look at the time frame here. We will be back on the record at 2 p.m. based on our agenda. The committee stands in recess until 2:00 p.m.
Thank you.
And we are back on the record. Just so our listening and viewing audience can be aware, St. Thomas is experiencing a power outage. Our legislative generator in St. Thomas is having a major glitch. But thank God that we have a brilliant media services here who are able to work around some power outages. And so we are able to join based on their workaround. We have some of our members who have joined us remotely, who were in the chambers in St. Thomas, and we should still be coming live on YouTube, as well as the government access channel. So we have a level of redundancy in the legislature, and I'm really appreciative of the staff for doing that workaround. Madam Clerk, kindly proceed with reading Block 3 of today's agenda into the record.
Block 3, 2 p.m. to 3 p.m. Bill number 36-0101, an act to provide for continuity of operations in the Supreme Court of the Virgin Islands in the event of prolonged judicial vacancies, proposed by Senator Novel E. Francis Jr. Invited testifiers, Ms. Regina D. Capart-Peterson, Administrator of Courts, Judicial Branch of the Virgin Islands. Mr. J. Russell B. Pate, Esquire, President, Virgin Islands Bar Association. The Honorable Gordon C. Ray, Esquire, Attorney General, Virgin Islands Department of Justice. Ms. Julie S. Todman, Esquire, Chief Territorial Public Defender, Virgin Islands Office of Territorial Public Defender. Madam Chair, this concludes the reading of block number 3.
Thank you so much, Madam Clerk, for the reading. Who speaks on behalf of Bill number 36-010? Senator Novel E. Francis Jr., you're recognized.
Thank you very much, Madam Chair, and good afternoon to you and my colleagues, as well as the testifiers. It is my honor to present Bill number 36-0101, an act to provide for the continuity of operations in the Superior Court of the Virgin Islands in the event of a prolonged judicial vacancies. This bill is presented at the request of the Judicial Branch to address the long-standing challenge of judicial vacancies. A common complaint among the court is the time it takes for cases to be heard, yet the greatest contribution factor to case backlogs are judicial vacancies. During the judicial vacancies, the court have depended on senior citizen judges to fill the gaps. However, two things have strained the current system. First, there are limitations to the existing statute, which include the restriction that senior citizen judges can only serve 180 days. And two, traditionally, it takes more than 180 days for nominations and confirmations to be made by the executive branch. The testifiers, particularly Court Administrator Regina D. Xavier Peterson and Justice Harold Willocks, will present strong arguments to the merits of this legislation. Essentially, by creating opportunities to maintain sufficient number of judges, this bill positions the judiciary to both maintain standards for case resolution and reduce the backlogs that have been plaguing the court and our legal system and the community. I'm not a member of this committee, and I ask for my colleagues' support in moving this legislation along so that, again, we could give the courts the tools that they need to be able to be effective and efficient in their services to this community. Thank you very much, Madam Chair, for the time and opportunity.
Thank you so much, Senator Novel Francis Jr. Colleagues, we have before us all of the testifiers. I want to begin by asking each testifier just to do a mic check and state your name as well as your title. We will begin with the Administrator of Courts.
Good afternoon, Regina Xavier Peterson, Administrator of Courts.
Good afternoon, Harold Willocks, Associate Supreme Court Justice.
Good afternoon and welcome to the both of you.
Good afternoon, Gordon Ray, Attorney General.
Good afternoon and welcome.
Good afternoon, Russell Pate, President of the Virgin Islands Bar Association.
Good afternoon and welcome. And joining us remotely, because she had to switch, and I really appreciate this, Attorney Todman, that you had to leave our chambers and go to your office. Good afternoon. We're just doing a mic check, and also to make sure we can hear you. Repeat? We didn't hear you clearly.
Good afternoon, Senator Joseph. Can you hear me?
Yes, I can.
Julie Smith Todman, Chief Territorial Public Defender.
Okay, great. Thank you so much for bearing with us and pushing through. At this time, I will ask Ms. Regina Xavier Peterson, Administrator of the Courts, to begin by reading your testimony on the record.
Good afternoon, Honorable Chair Joseph, Honorable Vice Chair Gittins, Honorable members of the Committee on Rules and the Judiciary, Honorable members of the 36th Legislature present, legislative staff, ladies and gentlemen. I am Regina Xavier Peterson, Administrator of Courts and Head of the Judicial Branch Administrative Office with primary responsibility over the day-to-day internal, non-judicial operations of the branch, including assisting the Chief Justice in making recommendations to the Legislature of the Virgin Islands as appropriate for changes to the organization, jurisdiction, operation, and procedures of the courts which are appropriate for legislative action, as well as any other changes that promote the effective and expeditious administration of the judicial branch and the Virgin Islands court system as outlined in 4 VIC Section 4C3. The authority to appoint judicial officers to assist judges existed in Chapter 3 of the Virgin Islands Code and in the 1921 codes, which allowed the appointment of court commissioners who acted to assist the district court judge in resolving cases and to act when the district court judge was absent from the territory. Bill 360101 speaks to a 49-year-old judicial function, the appointment of senior sitting judges to 1, temporarily oversee the docket when one of the 10 authorized Superior Court judgeships, or 4, authorized magistrate judgeships is vacant due to the incumbent's elevation, death, resignation, retirement, or term expiration. 2, combat case backlogs, overcrowded dockets, and other delays by hearing a defined class of cases to permit active judges and magistrate judges time to concentrate on complicated, multi-issue, and/or time-consuming cases. And 3, to hear a specific case when every active judicial officer qualified to hear the case has recused due to an ethical or other conflict. When I appeared before this committee in February, I specifically identified the limitations placed on this authority in November as a significant challenge facing the judiciary. So I understand the invitation to me to testify on this bill in that context. However, because this is a judicial function and affects the administration of justice in the Virgin Islands, I am pleased to have with me today Associate Justice of the Supreme Court, Harold W.L. Willocks, to speak on the limitations and the compromise to reinstitute a critical tool used to assist with the management and caseload, with management and caseload reduction, because as a former presiding judge, who was once responsible for case assignment and management in the Superior Court of the Virgin Islands, He made recommendations to the Chief Justice for the appointment of senior sitting judges pursuant to the then existing statutes and court rules. When his own terms of service expired without nomination, he also served in senior sitting status, covering and disposing of hundreds of cases. So with that, I will turn the testimony over to the Honorable Justice Harold L. Willox.
Thank you. Excuse me, thank you. Good afternoon, Honorable Senators, General Public. The judiciary began fiscal year 2025 with 11,666 cases pending and awaiting disposition. As of June 30th, 2025, an additional 10,168 new matters have been filed and 9,097 matters have been disposed of for a case clearance of nearly 90%, which results in a current caseload of 12,737. Approximately 1,300 cases are assigned to the three judges who will retire at the end of their 180-day holdover period, and for whom to date no new nomination for replacement has been sent. As we have informed this body previously, except for the impact of natural disasters and the pandemic of case management within the branch, judicial vacancies are the greatest contributing factor to the growth of pending caseloads over the past 2 decades. Only judges can exercise judicial power, and with the exception of magistrate judges, the judiciary doesn't hire judges. The governor must nominate an individual to serve as a judge, and the legislature must provide an advice and consent to confirm the process. In May of this year, the terms of 4 out of 10 judges expired. Only one judge, the Honorable Jessica Gallivan, who is now the presiding judge based on the rules of seniority, was renominated to a second 6-year term prior to expiration of her term. Judge Gallivan was confirmed during the 180-day holdover period without any adverse impact to caseload management in the family division in St. Croix. That, however, may not be the case for the other 2 judges whose terms have come to an end. Judge Deborah S. Watlington, who is the family court judge in the St. Thomas St. John District, Judge Kathleen Mackay, a general jurisdiction judge in the St. Thomas St. John District, and Judge Douglas Brady, a general jurisdiction judge in the District of St. Croix, have all indicated their intent to retire, and to date, no names have been submitted to replace those judges who plan to retire. To be clear, in less than 60 to 7 days, the holdover period for the incumbent judges will expire, and the administration and management of their caseload will be left to the redistribution and otherwise reassignment by the presiding judge, Gallivan, until such time as new judges are confirmed. To provide further context to the current crisis, none of the judiciary making the pertinent provisions of the Virginal Code clearly contemplate that the governor will either reappoint an incumbent judge or select a new judge before the end of an incumbent judge's 6-year term, and the legislature will confirm. If not before the expiration of the 6-year term, then certainly within the 180-day grace period, so there are no adverse impacts to case management. However, this theory or assumption has not necessarily held true. Historically, with few exceptions, nominations have been significantly delayed, often leading to breaks in judicial service and confirmations well beyond the expiration of the 6 months grace period, making a specialized tool, the appointment of senior sitting judges, commonplace out of necessity. The judiciary will certainly face a significant crisis of judicial vacancies come November, and it's also important to note that the terms of 2 more superior judges will expire in 2026. The irony is that despite the special audit bill that was signed into law in November, all of the retiring judges qualified to reside as senior sitting judges over the 1,300 cases, but only once the Chief Justice certifies that no sitting judge can preside over the 1,003 cases due to a conflict. This requirement is not only time-consuming and only burdensome, but also highly impractical. This is an undeniable impact on the change in the law, and this certification requirement still exists in this new bill. If I may take judicial privilege, if I may, let me just put it in layman terms. I know it's not on my statement, but I do think, Madam Chair, if I may, I think it's important enough that I take a minute to explain the impracticality of the certification. What the certification does is that the Chief Justice would have to make certain that all of the existing judges, all 5 judges, must review all 1,300 cases to make certain that there is no conflict. Once that is done, when each judge certifies or states that no case, that there is no conflict or that there is a conflict, then and only then the Chief Justice will be able to assign a senior sitting judge. I need not go farther with the overly burdensome and how impractical it is, but what that does is it causes judges to actually put down what they have to do to address this certification issue. Thank you, Madam Chair, for allowing me to give my opinion, my personal opinion on it. To ensure continuity of the most critical of judicial functions, the management and disposition of cases, Section 1 of Bill 36-0101, would amend Title 4, Chapter 5, Section 72A of the Virginia Code to strike the 100-day limit of service after the expiration of a judicial term and allow the judge to continue to serve unless renominated and confirmed or the confirmation of a successor occurs. This change should inspire timely nomination, but importantly, eliminate the need for entire caseloads to be reassigned on an interim basis. That is the current process in the federal judiciary, where a district court judge serves after expiration of the 10-year term until his or her successor is appointed and qualified. Section 2 would amend Title 4, Chapter 5, Section 74A of the Virginia Code by designating the existing language as Section 74A and amending it to establish a mechanism to appoint a former judge to hear a case or cases due to conflict, disability, absence, suspension, or other disqualification or unavailability of a current judge, and to permit the Chief Justice to waive the 12-year service requirement upon further certifying, once again, the word of certifying, that no former judge possessed at least 12 years of service is available to hear the case or cases. That is important because currently in the territory, only 3 former judges and 3 retiring judges meet the 12-year requirement, and they have to be willing and able to serve. Section 2 further creates a new section, 74AB, which authorizes the appointment of former judges to serve as senior sitting judges for renewable terms not to exceed 1 year. Section 3 would amend Title 4, Chapter 8 of the Virgin Islands Code to create a new section 127, which authorizes the Chief Justice of the Virgin Islands to recall with his or her consent a former justice of the Supreme Court, former judge of the Superior Court, or a former magistrate judge of the Superior Court without regard to years of prior service for temporary service as an acting magistrate judge of the Superior Court. This very well could become a critical tool as 3 magistrate terms will be expiring within the next 6 months, and we continue to face challenges with recruitment. Finally, Section 4 would amend Title 4, Chapter 8, of the Virginia Code to create a new Section 128 to authorize the presiding judge of the Superior Court to appoint no more than 4 members in good standing of the Virginia Bar to serve as a part-time magistrate judge for terms not to exceed 3 years, and to place limitations on the types of matters such part-time magistrate judges are authorized to hear, subject to the approval of the Chief Justice. These provisions, taken together, will ensure that the judicial branch not always has access to its most important resources, judges, but the flexibility to temporarily assign them where they are needed most. The judiciary has and always will challenge itself to increase operational efficiency and effectively manage caseloads. The public we serve and the other 2 co-equal branches of government expect and demand no less. This demand isn't something new. but the judiciary needs more tools and funding, not less, to meet and rise above these challenges. The responsibility to nominate must involve advanced planning and must be done timely to avoid or otherwise mitigate the challenges a judicial vacancy creates, let alone multiple vacancies occurring at once. On behalf of the judicial branch of the Virgin Islands, Administrator Peterson and I again thank you for the opportunity to provide testimony in favor of Bill number 36-0101. Thank you.
And thank you so much, Associate Supreme Justice Willox, for your testimony. At this time, the chair will recognize the Honorable Gordon Ray. You can begin reading your submitted testimony into the record.
Thank you. Good afternoon, Chair Carla Joseph, Committee on Rules and Judiciary members, other senators, legislative staff, and the listening and viewing audiences. I'm Attorney General Gordon Ray, and it's an honor and privilege to appear before you this afternoon. The Department of Justice appreciates the opportunity to comment on Bill number 36-0101. The Department of Justice has completed a preliminary review of the bill and offers the following comments. The stated purpose of Bill number 36-0101 is to amend Title IV of the Virgin Islands Code, Chapter 5, Sections 72A and 74A, and Title IV of the Virgin Islands Code, Chapter 8, to provide for the continuity of operations in the Superior Court of the Virgin Islands in the event of prolonged judicial vacancies. The Virgin Islands Department of Justice does not take a position on Bill number 36-0101. The department does, however, recognize the importance of providing for the operations of the territory's Superior Court, especially in the event of prolonged judicial vacancies. Establishing a plan for the continued operations of our courts benefits the territory by reducing operational downtime, ensuring compliance with local and federal laws and regulations, and enhancing public confidence in our Superior Court, which is responsible for protecting the rights and liberties of our citizens, upholding the law, and resolving disputes fairly, promptly, and peacefully as the territory's trial court of general jurisdiction. The Department of Justice does take note of the testimony provided by the Honorable Reese S. Hodge, Chief Justice of the Virgin Islands. During the 2026 budget hearing for the judicial branch of the Virgin Islands. During his testimony, Chief Justice Hodge discussed the need to increase staff as recommended by a work group created by the judiciary to examine the court's organizational structure and staffing challenges. The Department of Justice applauds the legislature's act to amend the law to reflect the current reality within the territory and welcomes the addition of new judges who can issue lawful and binding rulings, especially as the department is charged with prosecuting all violations of the Virgin Islands Criminal Code and representing the government of the Virgin Islands in all civil actions brought on behalf of or against the government. Additionally, increasing the number of judicial positions provides an opportunity for more lawyers with judicial aspirations, the opportunity to serve while expediting the administration of justice. And finally and respectfully, while the Department of Justice strongly agrees that the territory needs more judges to handle the massive caseloads across the courts, the department respects the right of the courts to determine the best method for filling vacancies until new appointments can be made. I thank the committee for allowing the Department of Justice to testify on Bill number 36-0101. This concludes my formal remarks, and I welcome any questions you may have. If I could also just take the privilege to mention briefly, I've been a member of the Virgin Islands Bar for about 43 years and have practiced during that time in the Territorial Court and, of course, in the Superior Court. Operation of that court is critical, and I've seen these vacancies occur and sometimes the amount of time it takes to fill them, and I respectfully defer to the judgment of the court as to what it views as the best method to see that these vacancies get filled and the court runs efficiently. So I support this.
Thank you so much, Attorney General Ray. This time, the committee will recognize Attorney J. Russell Pate. and President of the Bar Association, and Attorney Pate, you can proceed with reading your testimony into the record.
Good afternoon. Dear members of the Committee on Rules and Judiciary, I'm Russell Pate, an attorney practicing in the U.S. Virgin Islands for nearly 20 years. I'm also the current president of the Virgin Islands Bar Association for the past 60 years, the only second-time elected president of the Virgin Islands Bar Association. I'm familiar with the court delay in the U.S. Virgin Islands and the problems and lack of court funding, staffing, resources, and deteriorating courthouses and courtrooms. Bill 36-0101 is a step in the right direction. We're moving to a middle ground. The Supreme Court was believed to have too much power with retaining judges after their tenures expired, and the governor proposed legislation to curtail that power. Yet not having enough judges to resolve disputes hurts the public and undermines confidence in the rule of law. The first section of the bill closes the paradox that a judge not renominated leaves the bench even when a governor has not timely moved to nominate a new judge. This aligns with federal practice where our federal judges are appointed to 10-year terms by the U.S. President with confirmation by the U.S. Senate. However, when a federal judge is not renominated, that USVI federal judge is able to continue to serve until his or her replacement is nominated and confirmed. The second section loosens the court's ability to keep or fill in judges when needed. This is important, as special circumstances always do arise, particularly when dealing with thousands of legal cases. Here, the court has the ability to make a specific fact-finding decision to use a judge outside the normal statutory parameters. But however, as Justice Willocks did comment, it is overly complicated. Last, adding 4 attorneys as part-time magistrates has been recommended by the U.S. Virgin Islands for bars. Part-time magistrates has been recommended by the U.S. Virgin Islands Bar for years. These attorneys can help on low-level cases, probates, small claims, uncontested divorce, basic real estate or foreclosure issues on the civil side. On the criminal side, perhaps parking tickets and other quasi-criminal administrative fines without the possibility of jail time. In total, these represent thousands of small cases. The public wants justice now, and they deserve justice that's timely. Perfect justice is impossible. We are human. But 90% justice in 1 year is better than 98% justice 20 years later. The real key for administering justice is having all judicial positions filled with fair and hardworking judges at all times. Last, I'd comment on a balance of powers problem. The governor nominates judges. This is normal for many states that do not hold judicial elections. However, the governor also does retention or renominations. This is not best practices because the executive branch is a huge litigant before the courts. On the criminal side, the executive branch brings every criminal prosecution through the Department of Justice. On the civil side, the executive branch, via its multiplicity of agencies, is the defendant or plaintiff sometimes in dozens of cases every year. Thus, the governor is renominating judges with a personal stake in the litigation before those judges. When a person is nominated to be a judge, the governor touts the nominee's character and credentials. Yet when not renominated, the governor never makes a statement that that judge was a bad judge or explains the governor's reasoning. The judge is simply not renamed. These judges who are not renominated have no recourse, even if they were great judges but not retained purely for political reasons. This does not serve justice or the public at large. For fairness and to reduce the perception of conflict of interest, I highly recommend the Senate take over the renomination retention process. We will get better attorneys willing to serve as judges if those attorneys know that they will be evaluated on the merits of their work without a chance of losing their judgeship due to political whims. And if the Senate, upon review of the judge's record and demeanor and other factors, votes not to renominate or retain, then the selection of nomination of a new judge goes back to the governor. This is a fairer process with less conflicts of interest as the Senate is more impartial. The Senate is hardly ever a plaintiff or defendant in lawsuits, and in fact, if the Senate is sued or is suing, a specially appointed judge can be used so there's no issue or even appearance of conflict, then the public can and will have more confidence in our appointed judges. I'm happy to take any questions on this bill or other issues. I thoroughly enjoyed the Q&A and discussion the most. Thank you.
And thank you so much, Attorney Pate, for your comments. At this time, the chair will recognize Ms. Attorney Julie S. Todman, Chief Territorial Public Defender. You are recognized to read into the record your testimony. One moment, Attorney Todman. We're not hearing you. Are you unmuted?
There we go.
There we go. Your camera is up. Begin again from the top. I believe we can hear you now.
Yes, thank you. Good afternoon to the members of the Committee on Rules and Judiciary, members of the 36th Legislature, the listening and viewing audience. My name is Julie Smith Todman, Chief Territorial Public Defender. I thank the members and staff of the Committee on Rules and Judiciary for this invitation to testify on the proposed bill 36-0101. I write to you today, dear Senator Joseph, I write to you today on behalf of the Office of the Territorial Public Defender to provide you with our position on bill number 36-0101, which seeks to amend the qualifications and appointment process for judicial officers in the Superior Court. Chief Justice Reese S. Hodge made a clear and direct request for the passage of Bill 36-0101 during his recent appearance before the 36th Legislature. As he explained, the judiciary is facing the challenge of multiple judicial officials currently facing reappointment or replacement. As the head of our judicial branch, Chief Justice Hodge is in a better place to understand the necessity of this request, and OTPD has no reason to doubt anything in his testimony. OTPD may be directly impacted by the proposed legislation. Should the bill result in an increase in the number of judges or magistrate judges hearing criminal matters, it will naturally lead to an increased demand for legal representation. OTPD represents the vast majority of criminal defendants appearing before the Superior Court. While an increase in judicial officers does not necessarily lead to more cases, it will certainly result in more courtroom hours for the cases already assigned. One attorney, of course, cannot appear before multiple judicial officers at the same time. As I have previously testified before the legislature, our assistant public defenders already operate under heavy caseloads. An increase in courtroom time may well necessitate additional professional staff for our office in order to ensure adequate representation and maintain the quality of our defense services. While these comments are brief, OTPD sincerely appreciates the opportunity to provide input on this important legislation and its potential impact on our office. Thank you, Senator.
Thank you so much, Attorney Smith Todman. Colleagues, I believe this rounds up all of the testimony on Bill 36-0101. And so we will begin our first round of questioning, allotting 4 minutes for questioning by each senator. We will begin with our secretary, Senator Avery L. Lewis. Kindly proceed with your 4 minutes of questioning.
Thank you. Good afternoon, colleagues. Good afternoon, testifiers. Good afternoon. I gotta be whopper. Good afternoon to the people of the Virgin Islands. Judge Olax.
Good afternoon, yes, sir.
How are you doing today?
I'm here.
Good, 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 good. It's better that you in my chamber than I in yours, but anyhow.
True.
Glad you're here today. With the creation of this legislation, how do you see it really being helpful to what's going on now? Could you expound on that to the best of your ability, please?
Sure. Well, the first section really is long overdue. That is going to fix at the least, I would say, 60 to 70% of the problem in terms of senior sitting. I'm going to try and do this as quickly as I can. I know you have it like that. Because as has been stated many times, you have that log with serve until replaced, eliminate 60 to 70% of the problem. As I said before, one of my major concerns is the certification. That is going to tie up the whole court system in terms of judges are going to have to go through 1,300 minimum cases, 1,300 cases to make certain that there's no conflict on whether or not they can sit. That is going to be counterproductive to the great job that you guys are doing with Section 1. Overall, I think it's a very good legislation. If the certification section could be thrown out, I think it will help the movement of cases.
Cool.
No, I'm sorry, go ahead.
No, well, I was going to ask a follow-up question to that.
Sure.
I want to coin this correctly.
No, it's okay.
With the pool of attorneys we have here in the Virgin Islands, what do you think the real struggle is to bring in the quality needed to the system?
You know, the problem is you ask the wrong person the right question. Listen, I'm always brutally honest, okay?
I welcome that. The candidness are good.
Okay. We have a problem in the judiciary, and we all share the blame. It's not the court. It's not necessarily the court. It's not necessarily the AG office. Not necessarily the public defender office. Okay. Cases aren't being moved. There are myriad amount of factors. Cases are dismissed sometimes because the office may dismiss it for whatever reason. Under the case law, the court, unless the court finds that there is something wrong or it's arbitrary or capricious, we don't get involved in it. Now, what's happening is that it's difficult to move cases. And again, I'm singling out the court. We share blame.
Yeah.
We don't share all of the blame.
I believe it got enough blame to go around.
Yeah.
But go ahead,
exactly.
please.
But the perception is that a court, it's like, because you're quiet, everybody pick on you. Well, that's what happens here. But the blame goes around completely, totally. We have to look out for in the criminal case, the defendant rights. And I have been an advocate that, look, I'm not going to dismiss a murder case because the government isn't ready or defense isn't ready. Been there, done that. I've been involved and I've seen what the repercussions are community-wise. So I've granted continuances simply because I know that on the street, what may happen if they get wind of it is going to be dismissed. So you have a lot of factors involved that would require me to be a little longer than 4 minutes to really truly explain the dynamics of the problem that face the judiciary.
Thank you. Madam Chair, if I may ask.
You may wrap up.
Yes. Attorney General.
Yes.
Do you see the proposed mechanism in this bill, such as the senior sitting judges and temporary magistrates, as sufficient to prevent operational downtime in the courts? Do you see that as a plus?
I see it as a plus. I think it will help. Whether or not it will cure the problem, I don't know. And time will only tell. But I think it's a step in a good direction. And I agree, there's often a lag time from when someone's term ends before a new judge can be nominated and go through that whole process we were discussing. And that's going to fill that gap with someone who can do the work. The court backlog is horrendous, as you've heard, over 12,000 cases now. I've been very conscious of that. And what I've been trying to do actually is to get us to move more cases than we bring in. And I can just want to report to you that during this past year, I've watched the statistics every month, we have actually resolved more cases than we have taken in, which is helping to reduce a backlog. But obviously, that's a long process.
I thank you for your responses. Judge Wellock, I thank you for your response. Madam Chair, I thank you for the time and the flexibility. I know we're moving in the right direction. I thank the bill sponsor, especially like I see Mr. Dishabert Peterson nodding in consent, so I think we're going in the right direction today. Thank you.
Thank you so much, Senator Lewis. I believe we were encountering a little technical issue. So the committee stands in recess for 10 minutes. Heiliger. And we are back on the record. At this time, I'll recognize Senator Francis Heiliger for your 4 minutes. Senator Francis Heiliger, kindly proceed with your line of questioning.
Good day. Good afternoon once again to my colleagues. Good afternoon to the people of the territory. Good afternoon to the testifiers. As it relates to this piece of legislation, the first couple of things I wanted to ask from the Superior Court and the Supreme Court, I wanted to know, do you believe that assigning senior sitting judges or part-time magistrates will actually reduce backlog or just redistribute the cases? Because I know we have to figure out a way, but you firmly believe that going this route will actually accomplish what we want to accomplish?
Without question, the judicial branch didn't simply just give senior sitting judges as a favor. We meaning the Chief Justice, the presiding judge, monitored. And we have statistics as of June that showed that, I can't recall the amount of cases that were closed. So there is productivity without question. And so when you look at the statistics, you find that there's productivity. I think from the last report in June, I think there was about 20 or 30 cases closed, or a number of probate cases also closed in St. Thomas. So without question, there's productivity. Most of the time, in fact, 99.9% of the time, when you have a senior sitting judge, they're very productive because most of the time they're closing out cases that they had before. And others, they're taking on, like when I left, the Honorable Judge Joe Mee took over my caseload, and he closed out about, off the top of my head, close to 11, 12 or more of that. So yes, no question.
When it comes, I know we just went through the whole budget cycle. When it comes to the finances, the prorated salaries for the senior sitting judges, per diem for the magistrates, do you think if this bill is passed, are you prepared, or was that something you potentially discussed during the budget hearing? You know, what are your thoughts on that?
I will yield to the money lady, Ms. Peterson.
Good afternoon, Senator Regina Peterson for the Administrative Office of Courts. So every year, senior sitting is a line item for us. We anticipate, we plan, and mostly because we have been in deep backlog management coming out of the pandemic. So from a budgetary standpoint, we've always had a line item because our plan was to tackle first the criminal jury, and we've made significant dents in the criminal jury because that was a priority coming out of the pandemic, but it's been a part of an annual plan to target those groups of cases where we see that we had significant backlogs, and we're seeing the progress. Like, for example, we're at a 9% thus far in 2025, with the work that's been done through June 30th, we're at a 9% reduction in civil, and then we may have a 21% reduction in criminal jury, and those are the things that we're tracking. And the way we track, we can see what the ebb and the flow is, where we're up, where we're down, where we may need to put some more resources because we see we're either at a gain or a reduction.
Okay, excellent. The Attorney General's office. I wanted to find out. I know that we've had some situations where judges had gone past this particular, I think it was 180 days, et cetera. Or even if we don't do something to improve how this setup is currently, and say we were stalling on this bill, does that open the door for potential litigation from, say, defendants that might feel that, hey, this person technically isn't really lawfully sitting, or what is the case? Because I want to make sure that across the board, as many things are going to be beneficial for the court as possible.
Well, I think if it's, if the bill is passed and if that provision is included in it, then you'd be safe, because the law would say that the person is entitled to be there and is there properly until someone else has been nominated and approved and gone through that entire process to take over from them. So you're not going to have somebody who's just there and it's questionable as to whether or not they're legally there.
Time.
Madam Chair, may I ask my final question? Thank you so much, AG.
You may proceed, Senator, with wrap up.
Thank you. My final question is to the Public Defender's Office. The statement that you made, of course, you might have an increase in cases, et cetera, and more court time. What is your potential solution for that? If this piece of legislation is passed, how could we then assist you if that will be the outcome based on what you shared?
Then we would need to hire more attorneys if we have more courtrooms to cover, because judges are jealous of their time, right? If they've scheduled something for a trial, and another attorney is in 2 courtrooms, right, or scheduled to be in 2 courtrooms, that judge wants to go forward with their trial or with their motion hearings, and so we may need additional attorneys to handle, to be in front of those other judges, those other courtrooms.
Okay. Well, thank you so much, Madam Chair. I appreciate the additional time. And when it's time to vote, I'll vote accordingly.
Thank you so much, Senator Francis Heiliger, for your line of questioning. At this time, Madam Clerk, you place 4 minutes on the clock for me. I want to begin my questioning. First, I want to thank everyone for being here. And I believe this is unprecedented that this committee in this legislature has had testimony from the judicial branch twice outside of the budget. And we have before us an associate justice from the Supreme Court. So I understand now the gravity of what is being proposed here. Yeah, and I appreciate it. Now, Associate Justice Willock, kindly indicate to us what really was the impetus of this legislation, because I know we did something. And I take full responsibility too, because, I woman up to my responsibilities. And I take full responsibility that we did something that perhaps put it a little bit out of kink. And so we need to rectify it. And I suspect that this mechanism, this piece of legislation, is going to help us to still be able to move those cases along expeditiously. So kindly indicate for us what this legislature did and how now we are repairing it, because we act quickly in this body.
Senator, that's an extremely dangerous question to ask, but
when you come from the place I come from, we are very much dangerous human beings, and we ask direct questions.
Well, and I have no problem with that. Listen, I've been around a long time. I understand the politics of politics. Yes. And I can understand why the initial legislation was passed, because of the perception.
Right.
And the perception was that some way, somehow, there was an attempt by the judiciary to circumvent, which it was not. We were trying to survive. We weren't trying to circumvent. We were into a situation, and we have to look at things realistically. Our judicial officers and the staff of the judiciary, I'm amazed at how hard they work. But we're coming off a 2-category 5, a pandemic, okay? This isn't just a matter of, oh yeah, you go in. We have backlogs in jury because we can't hold jury because of the pandemic. So whereas one may think that you've lost maybe 2, maybe 3 years, from the judiciary point of view, you've actually lost 4, 5 years. Because you can't hold any jury, and right after the hurricanes, you can't hold jury because you don't want the jury to be sitting down thinking on the repair of the house or anything else. So when you look at it that way, then you have you can understand. And let me just say this, that we don't have a $11,000 or $12,000 case backlog. That is our cases. Now, and if I may, I just need to explain a couple of things.
And that's what you're here for.
Thank you. You know, a lot has been said about a backlog. It's like you can call it, but you don't know what it is until you know what it is. All cases we have a time, and we're improving on that. We have a time schedule. They're classed in track 1, 2, or 3. Now, that's based on the court standard, and we're changing that. The Chief Justice Hodge is working on that. So when you talk about a backlog, you have to look at it within the confines of the court setting a time limit on cases. Did this case go beyond track 1? Because you can have a case that's, what is a backlog? If a case is 6 months old, is that a backlog? What if it's a murder case? Of course not. So the court internally set its time limit or recommendation for judges. Look, you need to trade this case within a year based on the complexity of it, okay? Now, I still have to say that, out of every sometimes misstep comes a good. I think Section 1 is excellent. I think that, judiciary, where the judiciary take our punches and say, okay. And that's fine. Like I said, I understand the politics of politics, but out of this comes something that's really going to help the judiciary. And let me just say this. Senior sitting judges are not replacement. They are set, they come in to handle set cases. And these cases are not new. So the AG office would have attorney generals assigned to it. The public defender or the defense bar will have cases assigned to it. So these aren't to say that we're bringing in new judges. No, they're coming in usually with having these cases already set, that they aren't new cases. So and that's strange. I'm not trying to be diplomatic. I'm just saying that that's what came down.
I like, and when I say dangerous, I try to get things out in the open.
Okay.
Because if you don't get it out in the open, then you're not able to get that common ground. I know sitting next to you is the Attorney General as well as the President of the Bar Association. And we've had extensive discussions, some on the record and some off. And every member here in the legislature right now are very concerned because our constituents are also calling us, indicating that, their cases have been sitting there and the like for a number of years. And at the bottom line, we need to understand and be clear on what we can do collectively to move those cases along. Keeping it in mind, yes, they are complex cases at hand, but also to hold the defendant and the plaintiff foot to the fire to not have these multiple continuances, which further delays the process and clogs up the judicial branch's ability to move those cases along. I want to ask a question. I want to ask, hold one moment for me. I wanted to ask the president of the Bar Association, Attorney Pate, what is your sense relative to this piece of legislation? I know you mentioned in there something that is, and it really caught my attention, that relative to the judge's reappointment, you think we should do away with the governor process of sending down nomination, and the legislature should take over that renomination position.
Thank you, Senator. Absolutely. Absolutely. There's a number of reasons besides what I dictated here in the letter. One is if you want good judicial candidates, which was what Senator Lewis talked about, if you're going to give up your legal practice and you've built that legal practice, most times judges are not coming in as new attorneys. You're coming in after 10 or 20 years as a attorney that's practiced in the courts. Now, granted, you can look back, and I think Almeric Christian as a judge was in his 30s, Robert Malloy in his 30s. There are people who are picked earlier in their careers, but generally you have some gray hairs, and you are giving up your legal practice in your prime earning capacity, and then you are at the whims of kind of politics, as we've spoken with Judge Willocks. If you cannot be renominated, not because you didn't do a great job, but just because of the political winds kick you off the bench, what do you go back to? And why would you take that risk to leave your practice? If it is done, and look at this, we had a lot of discussion about the public needs to know, the public perception. Well, what is a retention? There is nothing public about it. The governor either resubmits the name or doesn't. And if your name is not resubmitted, it's a black hole vacuum. You just were not renamed. You're off. Why? But if the Senate had a hearing on it and looked at the merits of each judge, what's your open and close rate? What is your demeanor? And then it can be discussed. Were you dealing with 1,000 small claims or traffic tickets? Or did you have very complex cases? Like Judge Willocks had very complex cases in front of him, along with murder cases, a huge variety on his docket. Some cases are extremely difficult with dozens of parties. Other cases may have been a very simple theft.
Okay, so I want to ask a follow-up question. With that recommendation, do you know of any other jurisdiction that occurs in? Wherein the legislative body is responsible after a judge has been sitting for how many years, and the legislature is responsible for the renomination of a sitting judge?
I believe there were 2 other jurisdictions. I can get that to you. The real issue is most states either have judicial elections, which I do not think that's beneficial for the Virgin Islands. Other states have a strict nominating and committee for the governor. And then secondly, a lot of states, the judicial tenures are not 6 years. They're 15. And also a lot of states have lifetime tenures, just like the federal government. So we're in a very strange situation where the tenures are extremely short, and the governor could be on the same case that they're suing about 6 years later after the nomination for the same judge dealing with that case with the same governor. So we're in a unique position, and we're a small enough community with a small enough amount of judges that the legislature could handle this itself instead of a legislative committee of attorneys.
Okay. All right. Thank you so much for that input. Senator Avery L. Lewis, you are recognized for your point of information. Kindly turn on the mic of the secretary.
Thank you, Madam Chairwoman. This afternoon we heard the side of the judges, but I'd like to ask the administrator of the courts, what does that mean for you and your staff, your team, when we bring on, not bring on, but bring back or bring on, senior sitting judges to augment the caseload? What does that do for your team? Do you have to bring in new staff, or illustrate that for me, please?
Regina Peterson, Administrative Office of Courts.
Please recognize Ms. Peterson, Mike.
It's on. What does it mean for my office? My office supports everybody. And our internal rules do require that if we appoint senior sitting and they need support staff, then I have to find the support staff. You know, some senior sitting judges, they don't ask for a law clerk, they don't ask for a secretary, they just want an office and they do their work. But we have had some that if it's a complex issue and they feel that they need assistance with research and stuff like that, that we will have to go out and hire a law clerk, you know, to assist with those functions. But I think that's part of operations. It's up to me to provide those resources because in the end, we want to get those cases resolved, and so we have to apply them where they're needed.
Okay, Judge Willocks, Justice Willocks, you had some information you also wanted to share. I just want to avail you of that.
Oh,
you
thank
still?
you. No, I just wanted to make the Senate aware that we are in the process of working on a continuation policy, a very aggressive one, because we do recognize the problem. And hopefully, I believe we're in that JMAC or so. Within a couple of months, we are going to, among a continuation policy, certain other policies or rules that are going to come about to address this whole, we're working on the continuation policy, excuse me, the updating of the, what we refer to as a guidance for case management in terms of how long do we, like basically a rule that said, look, standards, thank you. That said, look, if you have a misdemeanor, you should be able to try this case within X amount of period. And if not, and we also have the presiding judge rule where the presiding judge will be monitoring to make certain that the other judges are within this time schedule. And if not, do they need help or do they need whatever else? So we are putting things in place to make sure that the cases are going to be moving as quickly as possible.
Okay, thank you so much, Associate Justice Willocks, for placing that on the record. At this time, I will recognize the bill sponsor for your closing remarks.
As for my time or my closing remarks?
It's your time. You choose how you would like to use it.
Thank you. Thank you very much, Madam Chair, for the opportunity, and thank you for the support on the testifier's statement and on this very important measure as we seek to close what we felt was a loophole in the legislation and created a mechanism where there's some satisfaction both by the executive branch as well as the legislative branch and the judiciary as well. So I think it's well-rounded to be able to address this particular issue. What is of concern to me is that as we continue to contemplate the issue of backlogs, because, you know, there have been many discussion and all of my colleagues, as well as I have received a number of calls from our constituency in respect to these cases not being resolved in what they felt is a timely manner. Complex cases, criminal matters, you know, civil cases where, you know, these cases take a long time to come to some resolution. And of course, we see where victims have been victimized again. We see where suspect may go free or you know, remain in jail for a long extended period of time. So I believe that this is a balance, as we have heard from the judiciary, that in fact, you know, this is what is needed for them to be able to make some inroads in some of the pending cases that they have before them. I wanted to ask whether or not there is a mechanism that's being developed to ensure that there is some quality assurance. We have where, you know, in every facet where you have individuals that work hard to, you know, make things happen, and you have those that don't work as hard. So I believe that, you know, in instances where we're seeing where, you know, judges may not, you know, move their cases as timely as others, you know, what is the quality assurance? What is the mechanism that's being created to ensure that, you know, the constituency and the public be able to receive some assurance that as we move this legislation forward and we appoint senior sitting judge, that in fact they'll be able to see that we're closing the loophole on the backlog of cases and bringing some resolution to these matters?
Well, the quality assurance is, as I stated before, we adopted a presiding judge rule. That's one of the things that the presiding judge has to do is to monitor and make certain that the cases are moving. Now, it has to be done comprehensively. On top of that also, we're working on the continuation policy so that whether it's civil or criminal, you simply cannot come back in. Like I said, the court always gets the blame, but that's fine. Our backs are broad, we understand that. But
I thought it was the legislature that always get the blame.
We take more of the blame than you guys.
Okay.
But so, you know, it's no longer going to be where you simply come in 5 days before trial or day of the trial and say, Judge, I need a continuance because of my dog ate my homework or some ridiculous thing. So the continuation policy along with the presiding judge rule is going to offer some quality assurance. And part of the presiding judge rule is that one of the requirements is that they monitor, and if they find that a judge is not up to spliff, they must meet with that judge to find out what the problem is. And if they cannot be resolved, then the presiding judge must either report that judge to, going off of memory, either to the Chief Justice or to the Disciplinary Council to see what's going on. So, yeah, we do have that.
Very well. In that chain of events, how do we keep the complainants? How do we keep you know, the victims and others? How are we keeping them informed about what's happening within their case space?
Well, I believe that once, and hopefully it'll be before the end of the month, that everything is in place. You don't want to do anything piecemeal. When those come out, and then the administrative courts, who's very, very good, will notify the public. But as of right now, we are still fitting the pieces in, and it may be another month or two. When that comes out, then the public would know through the administrative courts.
Very well. And finally, Madam Chair, if I may just wrap up here.
You may proceed, Senator.
How are we utilizing technology to be able to support and assist us in this endeavor?
I'm laughing because, look, I'd have problems turning on my cell phone. I would yield to the administrative court. Yes.
Regina Peterson for the Administrative Office of Courts. Technology is your friend, but it can also be your foe. And so it comes down to a lot volume and capacity. You know, we have introduced new CMS, e-filing, making things more accessible. On the horizon are, you know, considerations for online dispute resolution, but we also have to look at our capacity to implement, one, and two, our audience in terms of how technologically savvy our especially pro se litigants and others, because it's great to have the technology, but you have to have some kind of forecast of how many people we see utilizing this service to make it a worthwhile investment, because it is a significant investment to implement you know, those new portals and meet expectations, but we have to realize we're not just meeting expectations for Gen Z, because they're not the only ones in our court systems. So we have to just kind of utilize a measured approach when we're doing that.
Thank you very much. I'm happy to be the sponsor of this legislation to be able to close this loophole. And I, you know, again, I was reluctant to ask the Bar Association or the Attorney General because they have to appear in court. And I will continue to be the one to advocate on their behalf to make sure that there is some timely resolution to these matters, because in fact we all get the calls. I'm sure the AG's office, the Bar Association, you get them as well in terms of your timely resolution to these cases. All right, thank you very much for the time and opportunity, Madam Chair.
If there are no other burning questions, do I hear a motion?
That's right. Good afternoon.
Senator Avery L. Lewis, you are recognized for your motion.
Madam Chair, I move that Bill number 36-0101, an act to provide for the No, man, this isn't for you.
That's me.
I'm moving your bill. That's a different bill, a different block. Well. Tanida well sa popa. Madam Chair, I move Bill number 36-0101, an act to provide for continuity of operations in the Superior Court of the Virgin Islands in the event of prolonged judicial vacancies. We voted unfavorably in the Committee of Rules and Judiciary and forwarded to the full body for further consideration and action. I so move.
Second.
Bill number 36-0101 has been properly moved by Senator Avery L. Lewis and seconded by Senators Clifford Joseph, and Alma Francis Heiliger. Roll call on Bill number 36-0101.
Senator Carla J. Joseph?
Yes.
Senator Joseph Ye? Senator Kenneth L. Gittins? Senator Kenneth L. Gittins, yea. Senator Alma Francis Heiliger?
Yes.
Senator Alma Francis Heiliger, yea. Senator Angel L. Boquez Jr.? Senator Boquez Jr. absent. Senator Clifford A. Joseph? Yes. Senator Clifford A. Joseph, yea. Senator Avery L. Lewis?
Yes.
Senator Avery L. Lewis, yea. Senator Milton E. Potter? Senator Milton E. Potter absent. Madam Chair, you have 5 yeas, 2 absent.
Thank you so much, Madam Clerk. Bill number 36-0101, an act providing for continuity of operations in the Superior Court of the Virgin Islands in the event of prolonged judicial vacancies, has been favorably acted upon in the Committee on Rules and Judiciary and will be forwarded to the full body for further action and consideration. Do we have any closing remarks by the proponent? Hearing none, the committee stands in recess for 1 minute. Very good. Release the judges when you get back. Okay.
The Committee on Rules and Judiciary is back on the record. Just completed Block 3. And at this time, I'll excuse the testifiers, Judge Willock, and that's it. Or you staying for? No, you're staying for moral support.
Yeah, I'll just be here.
You could stay, bro. No. You welcome. You welcome.
No,
you
no
welcome.
good looks, just
Yeah, you welcome. You welcome.
Okay.
You're welcome. Madam Clerk, could you read the agenda for Block 4 for me, please, into the record? Into the mic, please.
Block number 4, 4 to 5 o'clock. Bill number 36-0112, an act amending Title 4, Virgin Islands Code, Chapter 31, Section 516, increasing the filing fee for general civil complaints in the Superior Court of the Virgin Islands, and Title 5, Virgin Islands Code, Chapter 41, Section 426, allowing the collection of 9% prejudgment interest when an offer of judgment is filed with the court, proposed by Senator Carla J. Joseph. Invited testifiers, Ms. Regina D. Chaport Peterson, Administrator of Courts, Judicial Branch of the Virgin Islands, Mr. J. Russell B. Pate, Esquire, President, Virgin Islands Bar Association. Madam Clerk, this concludes the reading of block number 4. Mr. Chair, this concludes the reading of block number 4. Sorry.
Thank you. And it's Ms. D. Shebert. I don't want no problem with the court this afternoon. As it pertains to bill number 36-0112, who speaks to this bill?
I do, Mr. Chairman.
Senator Carla Joseph, you may proceed.
Thank you so kindly, Mr. Chairman. Colleagues, I am honored to present and introduce Bill number 36-0112, an act amending Title 4, Virgin Islands Code, Chapter 31, Section 516, increasing the filing fee for general civil complaints in the Superior Court of the Virgin Islands, and Title 5, Virgin Islands Code, Chapter 41, Section 426, allowing for the collection of 9% prejudgment interest when an offer of judgment is filed with the courts. This measure seeks to modernize and enhance the operation of our judicial branch. This legislation addresses two critical areas: the filing fees for civil complaints and the prejudgment interest rate, both of which are overdue for adjustment to align with current economic realities and best practices across the nation. This bill proposes increasing the filing fee for general civil complaints to $150, which is currently $75, a modest adjustment that reflects the median filing fees in state courts of general jurisdiction. It also expands the fee structure to include affirmative relief complaints such as cross-claims, counterclaims, and third-party complaints. Importantly, these fees will be directed to the Judicial Branch Improvement Fund, which I have amended after receiving the testimony from the administrator of the courts, and ensuring that our aging court facilities in the territory receive the upgrades they desperately need. This investment will enhance the physical appearance and functionality of our courts, benefiting both the judiciary and the public. Additionally, the bill raises the prejudgment interest rate from 4% to 9%, bringing it in alignment with the majority of our states across the great United States of America. This adjustment ensures that the plaintiffs who have been wronged are fairly compensated for the delay in payment and the full opportunity of cost of money. By allowing plaintiffs to file the offer of judgment, this bill also encourages early settlement of disputes, reducing the burden on our courts and expediting, I have to stress this, expediting justice. Thank you so much, Mr. Chairman, for the time.
Thank you, Senator Joseph. Ms. As it pertains to the court, Ms. Shabert, Peterson, you're the one giving testimony?
Yes.
Mr. Pate, only you, Attorney Pate, only you giving testimony today?
Yes.
And I don't see anyone else online other than Senator Francis Heiliger. Thank you. Ms. Shabert, put your name and position on the record and begin. And you may proceed.
Regina Peterson, Administrator of Courts. Good afternoon, Honorable Chair Avery, Vice Chair Gittens, and who I know is listening, honorable members of the Committee on Rules and the Judiciary, honorable members of the 36th Legislature, legislative staff, ladies and gentlemen. I am Regina D. Xavier Peterson, Administrator of Courts, and it is my pleasure to appear before this honorable committee to provide testimony with regard to Bill number 360112, an act amending Title IV, Virgin Islands Code, Chapter 31, Section 516, increasing the filing fee for general civil complaints in the Superior Court of the Virgin Islands, and Title V, Virgin Islands Code, Chapter 41, Section 426, allowing for the collection of 9% prejudgment interest when an offer of judgment is filed with the court. Joining me today is the Honorable Harold W.L. Willocks, Associate Justice of the Supreme Court and a former presiding judge of the Superior Court. As indicated in this title, Bill number 360112 covers multiple subjects. Section 1A amends Title IV, Section 516 of the Virgin Islands Code by raising the filing fee for complaints, petitions, or applications in the Superior Court from $75 to $150 and adding cross-claims, counterclaims, and third-party complaints to this fee schedule. Based on the whereas clauses that precede it, these changes appear to be motivated by rising inflation and the existence of much higher filing fees in other jurisdictions, and the judicial branch does not necessarily oppose this approach in principle. However, the judicial branch firmly believes that the setting of filing fees in the courts of the Virgin Islands should be a matter of judicial administration. Title IV, Section 4C10 provides that the administrator of courts, subject to the authority of the Supreme Court and the Chief Justice, shall propose filing fees and other fees in the Virgin Islands court system. Furthermore, Title IV, Section 514 of the Virgin Islands Code grants the Supreme Court the authority to set all fees not specifically set by statute. However, it is true that most existing court fines, fees, and costs have been established by statute, and as such, require legislative action to change or otherwise adjust. In this regard, the judiciary is already in the final stages of a comprehensive review of court fees and will issue recommendations for fee changes. It must be noted that the $150 filing fee proposed in Bill 360112 is just one of 13 categories of fees included in 4 VIC Section 516. Section 1B of Bill number 360112 provides that all such fees be deposited in the Superior Court Capital Improvement Fund rather than the government's general fund. The judicial branch does not oppose this change given the significant challenges it has faced with securing appropriations for major capital improvements. However, post the administrative unification of the courts in 2016, pursuant to Act number 7888, There's no need to establish or otherwise specify a superior court improvement fund as opposed to a judicial branch improvement fund. Every year, the Judicial Branch Administrative Office develops a comprehensive capital project schedule for all of its facilities, which is included in our annual budget presentation. We should have the requisite flexibility and discretion to administer all funding with respect to those planned infrastructure improvements. And I'm happy that the Senator is going to move that amendment in that respect. Section 2A of Bill number 360112 increases the rate of post-judgment interest from 4% to 9%. The judicial branch cannot provide input on Section 2A as, despite its placement in Title V, we believe that the setting of the post-judgment interest rate is a matter of public policy, which is the sole responsibility of the legislature. Finally, Section 2B creates a statutory procedure through which a plaintiff may make an offer of judgment to a defendant and will receive prejudgment interest at 9% per annum from the date of filing of the complaint if the verdict at trial is higher than the offer of judgment. Again, the judicial branch takes no position on this change. However, we note that the procedure that Section 2B seeks to codify is already, in part, a rule of judicial procedure, and the Supreme Court of the Virgin Islands possesses the constitutional, statutory, and inherent authority to establish the rules of judicial procedure for the courts of the Virgin Islands. In accordance with Title IV, Section 32F3 of the Virgin Islands Code, the Supreme Court established an advisory committee on rules in 2016. The Advisory Committee on Rules consists of judicial officers and attorneys from all practice areas, plaintiff, defense, and government, and among other duties is charged with continuously studying and monitoring all court rules and suggesting amendments or other changes to those rules. The Advisory Committee drafted the Virgin Islands Rules of Civil Procedure, which went into effect on March 31st, 2017, and which already include an offer of judgment provision. That provision, which is in the civil procedure, Rule 68, allows either the plaintiff or the defendant to make an offer of judgment before trial and to pay the other side's attorney's fees and other costs incurred after the offer is rejected and the eventual recovery is less favorable than the offer rejected. Section 2B effectively seeks to amend Civil Procedure Rule 68 by allowing only one party, a plaintiff, to also recover 9% prejudgment interest. We take no position on the prejudgment interest aspect of Section 2B, but believe that the authority to amend Civil Rule 68 rests with the judicial branch, and that the offer of judgment proposed by Section 2A is a matter best suited for the Supreme Court's Advisory Committee on Rules. On behalf of the Judicial Branch of the Virgin Islands, I again thank you for providing me with this opportunity to provide this testimony with regard to Bill number 360112, and both Justice Willocks and I shall remain available to answer any questions that you may have. Thank you.
Thank you. Attorney Pitt.
Good afternoon, Senate Chair Lewis and members of the Committee on Rules and Judiciary. I am Russell Pate, an attorney practicing in the U.S. Virgin Islands for nearly 20 years. I'm also the current bar president of the Virgin Islands Bar Association, and in the past 60 years, the only second-time elected bar president of the Bar Association. I'm familiar with court delay in the U.S. Virgin Islands, the problems of lack of court funding, staffing, resources, and deteriorating courthouses and courtrooms. I highly commend this committee on Bill 360112. The bill is very self-explanatory, so I will be brief. First, raising filing fees. This is for what I'd call big cases in the Superior Court. Those are contract, real estate, divorce, foreclosure, debt collection, business disputes, and personal injury to match up with filing fees across the United States. From my understanding, this does not apply to small claims in magistrate court, which will remain at $50, the lower amount. Filing fees are not at the discretion of the judge, like a penalty in a civil case. Any fines or fees that are at the court's discretion in civil or criminal cases go to the general fund so that there is no conflict of interest. However, in non-discretionary statutory set filing fees, these can be sourced and kept with the court to create a secure and steady stream of money that can be leveraged for capital improvements. We here all know the age and condition of the territorial, now superior courts on St. Croix and St. Thomas. The buildings are aged. They are old and aged. Further, this bill makes filing fees more fair. Instead of the plaintiff just paying $150 to file his or her or a corporate entity's lawsuit, any party that countersues or brings other parties in, like third parties, pays the filing fee of $150 too, for seeking affirmative relief of damages. For example, in toxic refinery litigation, where dozens of companies may sue dozens of other companies in one lawsuit, that case filing should not just be $150 when 50 companies are suing 50 other companies. One complex lawsuit could generate 100 affirmative counter cross-claims or third-party claims, creating a $15,000 filing fee, and rightly so for the complexity and amount of money in dispute. I will now move on to the section regarding prejudgment interest. At present, a business or a person seeking money for harm caused, if there is no sum certain money amount at the filing of the complaint, which is sometimes called liquidated damages, then no prejudgment interest can be awarded. Prejudgment interest in the Virgin Islands is 9%, which is consistent with many other states, though a number of states follow Massachusetts and have higher 13% prejudgment interest. So if you have a business case for breach of contract for liquidated damages pending in court for 10 years, or you have a foreclosure case for a sum certain pending for 10 years, you can get 9% prejudgment interest. However, if your case is personal injury or a breach of contract for non-liquidated damages, which includes consequential or incidental damages, or for any other human non-economic damages, human damages, there is no prejudgment interest. Unfortunately, the lack of money interest creates a perverse incentive for more court delay, as the defending parties have an incentive to delay as the value of money goes down over time. This is Econ 101. Why pay more by an amicable resolution now when you can pay less 5 or 10 years down the road? Generally, 97% of civil cases settle, but when a case settles is a big issue of fairness. If they settle in year 1 of litigation versus year 10, right before trial, it's a huge difference, multiplying the massive burdens on the court and the justice system. Yet under current VI law, waiting to year 10 to settle is incentivized for the wrongdoer, as it reduces the real value of money paid because there's no prejudgment interest. To promote earlier resolution, many states have statutes which burden the party who rejected a fair and reasonable settlement offer with paying costs and interest on the delay. Bill 360112 looks very similar to Connecticut statute 52-192A, which is the statute's goal is to make parties internalize all the costs of tactical delay. This bill's interest provision creates an incentive for the parties not to delay litigation, knowing that interest costs will reflect inflation and consumer price increases, which is sadly very high lately and likely to increase further with tariffs. In sum, this bill promotes fairness and timeliness. The interest provision will help people, particularly people and businesses which were done wrong and seek redress in a court of law. I'm happy to take any questions. I thoroughly enjoy the Q&A discussion the most. Thank you, and I'll make 2 comments, and I hate to disagree sometimes with the administrator of the courts that it's not a position I ever want to be in, but the issue on personal injury is that the courts have said that because it's not liquidated, the amount is not a stated amount in the complaint that you can propose. You cannot get interest on those damages. And then secondly, because our statute here, the Supreme Court has said many times we do not follow what's called the American rule, which is there's fee shifting in the states by statute. But here in the Virgin Islands, we have a statute that no matter what case you bring, you pay the attorney's fees. If you win, the loser pays your attorney's fees, except in personal injury. There's no shifting there. So you cannot actually shift in personal injury cases the attorney's fees in those. So you can move for quote unquote costs, but your costs are really deposition transcripts. They're very limited. Your paper copies and other things, and these have been Supreme Court opinions. So you're left without getting attorney's fees or interest. And this bill fixes that. It fixes a hole in the law to make it more fair. Thank you.
Thank you, Attorney Pate. Colleagues, we're going to go to a 3-minute round. We're going to begin with Senator Alma Francis Heiliger. You're up for your 3 minutes. Francis Heiliger.
Good day. Thank you so much. I really appreciate this opportunity in regards to this piece of legislation. I wanted to find out, I know that the representatives from the court were saying that this is only one out of many pieces of fees that could have potentially been impacted. Are you suggesting that it might be best if we try to do something comprehensive, or are you suggesting that it's okay to just deal with this one part, but you were just bringing the rest of them to our attention?
Regina Peterson, Administrator of Courts. We have, I think for at least the past 2 budget cycles, been discussing fee increase. And so my suggestion, or what I was highlighting, is the fact that we are working on recommendations that will probably address the other 12 lines in the statute, because we can't set those administratively. We have to make a recommendation to the legislature for any fee increases in those regards, in that regard. But we're perfectly fine with the recommendation.
As it relates to, okay, cool. It relates to the moving from 4% to 9%. Do you see that as a potential strain on, say, businesses, or, you know, whatever the case is, to jump the 5%? Or do you think it's still it's a reasonable amount? Also, to go from the 75 to the 150, does that potentially, I know it's monies for the court, but does that potentially, you know, could hinder someone from coming and getting relief if they have to come up with the 150 per se? Your thoughts?
Regina Peterson, I will speak to the second item you raised. As I indicated, the first is a public policy that we are not going to put, put a position on record regarding. But with regard to the class of fees or petitions and applications, that class is for a grouping of cases where that fee is within reach, generally speaking, for the parties involved in those transactions. I believe, as Attorney Pate mentioned, it does not affect those in small claims. That's not to say that a recommendation to increase those other fees that would have course been well researched based on our market situation won't come later on, but I think on this line item that it is within reach and consistent with national trends.
Okay. Well, I don't have a problem with national trend. I just have a problem with how us as a people have to, we already have to pay for a lot of things that are much higher in the territory in addition to inflation. And sometimes when we try to mirror things nationally, sometimes we forget our people are already paying things much higher. So I'd be a little leery about making things too high, but I understand your thoughts on it, and I will vote accordingly when my opportunity comes. Thank you so much.
Thank you, Senator.
Attorney Pate, you wanted to weigh in?
Yes, Senator Lewis, if I could answer the senator's question. There's 3 parts to it. The first one was moving from 4% to 9%. That's inaccurate. Prejudgment interest in the Virgin Islands is 9%, but it's only for some cases. This bill makes it for all cases. It throws the net on everyone so it keeps it fair instead of being selective. So it is 9%. It's not moving up 5%. It's already at 9. Secondly, on filing fees, the 150, if you look at all 50 states, most states are more than that for their big civil cases. They're 175, they're 200. The federal courts, I think, now are $450. And the analogy I would use for Senator Heiliger is if you own a car and that car is $50,000 to buy it, or let's say $30,000, can you afford to put gas in it? Because your filing fee is just the gas for the car. If you're in the general civil litigation in the general court where Judge Willock sat, the $150 is the least of your expenses. The first deposition you take of the defendant in the car crash is going to cost you $1,000 to $2,000 for the transcript alone. The doctor that you have to come to trial is going to cost you $10,000. That's not even your attorney. To get a case to trial, a small case is $30,000. So if you can't pay the $150, you've got some serious problems. Now, the court does have what's called informa pauperis, that they will waive the $150. If you say you have no money and you prove that, it's waived. So this is not the issue. The cost for the court system, it's not about the civil complaint. There are other problems for the court system being that expensive with experts and depositions, but that's a whole other story.
Thank you. Thank you, Senator Francis Heiliger.
Thank you so much.
Senator Carla Joseph, you're recognized for your 3 minutes.
Yes, thank you so much, Mr. Chairman. I want to begin my line of questioning with a really great quote, because we're looking at cases being delayed. Justice delayed is justice denied. And really, it sends and it resonates with me because we have a lot of persons out there waiting for their justice, at least for it to come before the judges in the judicial branch. And we also want to be able to reduce the amount of delay. I know Justice Willock talked about the JMAC and consideration for those continuous guidelines. So I really appreciate this bill, and furthermore, I appreciate that the administrator of the courts took time out to review. And I'm more than willing, and we've been working together very well, to work with you as well as the judicial branch to assure that we are updating the code so that it is relevant and that we are no longer in a posture of having person filing various lawsuits that they aren't going to be able to get some kind of justice within 5 years or so. So I really am supportive. I want to ask one question of you, Administrator Disha Bird Peterson. Kindly indicate for us, if you have within you our knowledge, how many pending civil cases do you have right now?
In various categories, and this is not by district, you could say civil non-jury, as of June 30th, about 1,200 cases. Civil jury, and that's non-complex, 977 cases. And civil complex is closer to 1,700 cases. So you're talking about just shy of 4,000 in the civil division.
And how dated are they? What's your earliest or last date?
I haven't reran a case aging on those cases, but a lot of them do, especially the complex cases, of course, are the mass tort, toxic tort claims that date back to Hess and then Hovenza.
Right. And so, we really don't want what has happened based on what the president of the Bar Association, Attorney Page, said, is for people to wait out the time, and so that their payout or what have you is reduced. We want them to go to mitigation. We want them to mediate on these cases, and so that they are dismissed. Justice Willock, you wanted to say something?
That's okay. It's, the complex cases, the numbers are somewhat misleading because we have master dockets or master cases. So I saw you raise your eyebrow when you heard 1,700, but you may have in one master file 500 cases. I've handled many of them where a master case or master docket is 100, 150. So you put them in there when there are similar facts and issues. So when you're hearing that 1,700, in order for the court to manage those cases, they're placing what we call master cases, master dockets.
Okay, thank you so much for that clarification, and that's why we are good with it. Well, I believe right now, because we're pressed with time, amendment?
You're recognized, Senator Joseph, for your amendment.
Thank you so much, Mr. Chairman. Mr. Chairman, I would like to move and offer amendment number 36529, and it reads Amendment to Bill number 36-0112, which is offered by myself. Bill number 36-0112, Section 1, subsection B, is amended by striking Superior Court, capital, and inserting Judicial Branch. I so move.
Hearing no objection, so ordered.
And in keeping with
Do
that,
I hear a motion?
Motion, Mr. Chairman. Mr. Chairman, I would like to move Bill number 36-0112, an act amending Title 4, Virgin Islands Code, Chapter 31, Section 516, increasing the filing fee for general civil complaints in the Superior Court of the Virgin Islands, and Title 5, Virgin Islands Code, Chapter 41, Section 426, allowing for the collection of 9% prejudgment interest when an offer of judgment is filed with the court as amended. I so move.
Second. Roll call. Motion properly moved by Senator Carla Joseph, seconded by Senator Clifford Joseph and Senator Avery Lewis. Roll call.
Senator Carla J. Joseph?
Yes.
Senator Carla J. Joseph, yes. Senator Kenneth L. Gittins? Senator Gittins, yes. Senator Alma Francis Halliger?
Yes.
Senator Francis Halliger, yes. Senator Angel L. Bolkes Jr., absent. Senator Clifford A. Joseph? Senator Clifford A. Joseph, yes. Senator Avery L. Lewis? Senator Lewis, yes. Senator Milton E. Potter?
Yes.
Yes. Senator Potter, yes. Vice Chair, we have 6 yes and 1 absent.
Thank you. Madam Clerk, Bill number 36-0112, an act amending Title 4, Virgin Island Code, Chapter 31, Section 5166, increasing the filing fee for general civil complaints in the Superior Court of the Virgin Islands, and Title 5, Virgin Islands Code, Chapter 41, Section 426, allowing for the collection of 9% prejudgment interest when an offer of judgment is filed with the court has been voted favorably. As amended, has been voted favorably upon in the Committee of Rules and Judiciary and will be forwarded to the full body for further consideration and discussion. Motion, Senator Clifford Joseph.
I move to remove Block 5, consisting of bills number 360144, 360105, 360123, 360136 from today's agenda and have them placed on the next Committee on Rules and Judiciary agenda. I so move. At the call of the chair. I so move.
Second.
Second.
Properly moved by Senator Clifford Joseph, seconded by Senator Alma Francis Heiliger, Senator Avery Lewis, and Senator Carla Joseph. Roll call.
Potter.
And Senator Milton Potter. Second, roll call.
Hearing no objection.
Hearing no objection, so ordered. The Committee on Rules and Judiciary stands in No. Before that, I'll excuse the testifiers. Y'all have a great day. The Committee on Rules and Judiciary stands in recess for 1 minute.
I don't think that.
And we are back on the record. At this time, I really would like to thank all of my committee members for their attendance today and their participation. We really had a robust discussion. I also would like to thank my staff for staying here and staying in the paint until this time. And doing the work behind the scenes and in front of the scenes. I must commend also our protocol officer, Ms. Myrna Picard, for her work here, always being professional and providing that loving, kind, and efficient service. I also want to commend our Sergeant of Arms, Officer Jack, for being here. He's wearing green, my favorite color. He must know it, and he was placed in action and doing the work very precisely and efficiently. I deeply appreciate you. I would like to thank also our stenographers who are not here, that you can see them, but they are online taking copious transcript and notes and of the proceedings, so I also want to thank them. I also want to thank legal counsel for their work that they're doing. I want to thank the facilities management also for all the work that keep us running. But I want to really, at this time, say hats off and kudos to our public relations division here in the legislature, who, despite having a power outage in St. Thomas, they were able to take night, literally, and make day and get us through today so we were able to cover the items we have on the agenda. Kudos, mega kudos to all of you, and I deeply appreciate it. The Committee on Rules and Judiciary meeting for Monday, September 8th, 2025 is hereby adjourned.